Having one proof. Take item is my lord, dispose of that own my lord. That is wrong, my lord. That should have been 1261. That is pending, my lord.
It is not disposed of.
No.
It come with the
1261, my lord.
oh,
That should be 1261.
Okay, understood. On a prayer made by Sri G and Sayola London Senior Council. List on 20th
April.
20 April.
April.
Okay. Yes, 20 April. It is pointed out that though these matters were to be tagged with WPC 1261/2021, which is a pending matter, due to inadvertence, the number has been written as WPC 261/2021. Full stop. The same may be corrected, and the records of 1261/2021 be tagged along with.
Filed a motion some 4 days ago, my lord.
Hmm.
Listed tomorrow. There is some urgency.
Yes. Already filed, Mr. Borra?
Lordship,
Already filed.
4 days ago.
Oh, yes. Why not?
Hello,
Yeah.
have a similar prayer we have filed.
Yes.
Can it be come tomorrow?
Yes. Motion, no problem.
I have also a similar paper proposing one with petition tomorrow, madam. We have some urgency.
Motion.
Motion, madam.
Motion is
Tomorrow, madam. Right.
Please, my lord, I beg to mention item number 9 and 10, my lord. There is a my lord subsequent development, my lord. Government is causing inquiry, my lord. So matter may come up after.
9 is with also 8 is there. What about 8?
My lord, it is connected, my lord. I'll inform other side also, my
Let
lord.
the matter reach, or if you take their consent.
Yes, my lord, I'll
Mr.
inform the
Doctor?
doctor.
M. Datta, Minmoy Datta, I think is
Yes,
there.
I'll inform him of just now, my lord. May come up after vacation.
You
my lord.
take his consent, he may be otherwise ready.
No, my lord, agri party is the we, my lord.
Understood, but he is got
But
a
I'll inform, my lord. I'll inform over.
Mr. Borbi, I don't understand. He's got a separate petition. He may have some urgency. We don't know.
Anyway, my
matter
lord,
is
I'll
connected.
inform right now, my lord.
Inform and come back. We'll grant you the adjournment, don't worry.
Lordship, item number 16, may I pray for taking up the matter at 2 p.m. Lordship. There is an urgency in the matter, Lordship.
1-6.
Lordship, item number 16, we have filed an IA.
Okay, we'll try. No, it should reach in the first half. If it doesn't, we'll try.
Lordship, much of
Stay vacating application.
Lordship.
Which one
That is not a stay vacating for renewal of the stay order, Lordship. Some protection we are seeking from this court, Lordship. The petitioners, they are sought to be evicted from their homestead land.
Okay, let us see.
May I please, Lordship? Item number 38 and 39. Also on Tuesday, Lordship, while fixing the matter for today, also has granted liberty as to mention for upgradation, Lordship. Whilst I am matter, Lordship. After motion, can it be at after motion, Lordship?
38, 39.
Yes, Lordship. Has granted liberty to us.
Even 36, 37, we have also granted liberty. Mr. Sharma's matter. All matters are important. All liberties granted. Then we can only say that we'll see to it. Let's see.
After motion.
Let's see how long the motion takes. Yes.
Well, I am praying for listing of this matter for motion tomorrow, my lord. My obligement.
Clear, madam.
Motion tomorrow. Filed or not?
Yes, already.
Please, Lordship, mention for listing, Lordship, but orders matter, Lordship. Orders.
What is the matter about?
The matter relates to non-payment of contractual bill, Lordship.
Okay, next week,
Yes.
next Friday.
Yes, Lordship, much.
Yes, Mr. Bola.
Your lordship, my lord, in this matter, my lord, the Miadipatta land of the petitioner, there is a public road in front of his land.
Motion matter what?
Admission, my lord, in the next week, my lord, on 27 or 29, my lord. Obliged, my lord.
My lord, I have taken consent, my lord.
Yes. Item numbers?
Item number I am for
8,
9 and 10. my
8, 9 and 10. Not 8, 7. 7 and 8.
7, 8,
No, not 7. 8, 9 and
8, 9, 10.
And on the prayer of Sri G.I. Borbhuya. Matter stands adjourned to be listed on.
After Bihu vacation.
Forest Department aware.
Forest Department basically is a fishery matter, my formal party.
Fisheries Department, yes. Are you aware of this?
Mention could do after Bihu.
After Bihu. On the prayer of Sri. After the Bihu vacation. And then you write in item number,
819.
no, 8 to diba, and 8 to likhi diba. List along with so which has been fixed after bifurcation. 8, 9, 10, yes.
Wait, please, my lord. My lord, I am praying for this matter for withdrawal tomorrow, my lord.
Mr. Borbia, is there an interim order?
No interim.
For
For
withdrawal?
withdrawal tomorrow, my
Yes,
lord.
yes.
Obliged.
Please, Lordship. I am mentioning this matter for listing in admission column, Lordship.
What is the
Matter
matter
not
about?
listed as motion state, Lordship.
Matter about?
Matter about, Lordship, a huge amount, more than 4 crore has been withheld by the department, not paid.
For what reason? On what
For
account?
protection matter, Lordship.
No, withholding is on what account?
Bill amount, Lordship, he executed work more than 4 crore. He submitted the bills, but the same has not been paid.
Non-payment of bills.
Non-payment did not prepared at all bill. More than 4 crore.
Okay, let us see next week.
29th.
Next Friday.
Right. Highly
My lord, I pray for listing of the motion matter tomorrow.
Yeah, please, your lordship. I am praying for listing one matter, lordship, in the admission column, lordship.
What is the matter?
Matter is about lordship, PSU, lordship, and
PSO.
lordship.
What is the urgency of
Lordship,
PSO?
urgency that subsequently, lordship, in this month only, lordship, there is a threat, lordship. Some two miscreant has detained him with gunpoint, lordship. That's why.
Gunpoint? Where? Did you lodge an FIR?
Lordship, I lost FIR also.
Where, which place?
Lordship, this is Udalguri loss,
Okay, let's next Wednesday.
Monday loss.
Next Wednesday. Okay, next Monday.
Loss.
Next Monday.
Wait, please, your lordship. Lordship, I'm praying for urgent listing of an IA. Lordship,
Have you filed the IA?
Yes, lordship.
When do you want?
Tomorrow, lordship.
IA for what?
Actually, your lordship, I for SS is.
If she is making the mention, let her make the mention. Why are you interfering?
Sorry.
Lordship,
Yes.
urgent correction is required.
Correction, IA for correction.
Yes, lordship.
Okay, tomorrow.
Yes.
Duita function of other side, Beckham mention item number 5, lordship. That kindly adjourn for 4 weeks, lordship. My senior is out of his station.
Mr. Bhatti is not there. Okay.
Yes, lordship.
He's from the other side.
Yes, lordship. And
Okay, on the prayer made on behalf of Sri O.P. Bhatti, learned counsel for the petitioner. Matter shall adjourn by 2 weeks.
after the lordship.
Matter shall adjourn to be listed after the bifurcation. Okay, obliged. Item number 5. IPAC negative. What did Corona mention? Or Purana meter, product negative.
Lord, this dispute is going since.
We're discharging the caveat. R3 YS Manan, Senate Council, for the caveat who has lost this caveat in respect of an order dated 3/12/2022 passed by the in-charge additional registrar of cooperative societies, THD, BTC, with regard to withdrawal of the abeyance order against Messrs. Gadadhar Mean Samabay Samiti Limited. Full stop. The caveat would be heard in the event this court considers passing of any interim order. Caveat stands in charge. Yes.
Well, a petitioner before your lordship is Sureshwar means Samabay Samit. This was
You're
originally my.
Gadadhar.
No,
I am Gadadhar.
Okay, okay.
My lord, originally it is a Sureshwar means Samabay Samit Limited. That
Sureshwar.
was the one only. That is Sureshwar means Samabay Samit Limited.
Then it was
This
bifurcated.
this was, my lord, 1975.
Hmm.
I have been told that this registration is in the year 1975.
Hmm.
And we are all the members. My learned friends, client were also members. So there arose some.
Initially, there was one.
Yes, one. My lord, there arose when BTAG came into picture, my lord.
Hmm.
So certain members fall under BTAD, certain non-BTAD. So there was some dispute in it.
Hmm.
So that led to number of cases before the cooperative society also, before some grievances was placed forward before assistant register. One application was filed. Thereafter, some writ petitions also was filed before this honorable court from 2014.
Hmm.
Now, this is in relation to, my lord, bifurcation. Now, in 2017, there are few writ petition which my learned friend also have showed some copies of appeals.
Hmm.
The appeal was also filed against some order of the.
Now, ultimately, what is the
Now,
problem?
to the last order, that has to be looked into it, my lord.
Yes.
That I will just trouble you.
Now,
lordship,
Mr. Yusuf's Mannan's client has come up. It's a bifurcated society
by
order
bifurcation, yes,
after BTAD.
yes.
Originally, you were part of Solicitor.
Yes.
I am the one of, we were source.
Oh.
Everyone was source. After BKD, we became Godadhar, then they became.
Okay. When did you become Godadhar?
We became Godadhar in 2013,
13.
13. Our registration was. in
No
2013.
dispute with that.
That, my lord.
There was, only problem was we had a dispute because that was kept in
That
abeyance.
was kept in abeyance.
So we came before this honorable court initially. So ultimately, that kept in abeyance was withdrawn in the last order, which my learned friend,
Yes.
senior friend is challenging in this.
Okay, this is the 22 order, December 22.
Yes,
So my abeyance has been withdrawn. That is the,
this is what I am, and where now the crux of the
order.
matter. Yes.
So how are you?
Now.
How are you agree?
No, now the crux of the matter is, when there was a kept in abeyance, and when you have withdrawn it by the last order where we are before your lordship, prior to that, that bifurcation itself we have been put to challenge. This is the crux. The bifurcation was put to challenge.
2013
Yes,
bifurcation.
yes, because that's all proceedings to what was going on. Then ultimately, there was an order passed by registrar in 2017 that your lordship will kindly see now, my lord. Because ultimately, your lordship has to look into it. The bifurcation which was put to challenge by me. This is 93. Precisely, I will show 3 documents, my lord.
Page 93.
93. 18th of January 2017. 93. My lord, I'll try 94, my lord will kindly see. Page 94, last 2 paragraphs. Last 2 paragraphs. Again, white order, lordship got it, last 2 paragraphs. Again, white order. Dated
94 or 95?
94,
I think 95.
95.
I think 95.
94, my lord.
94.
94, last 2 paragraphs.
To comply with.
Again, white order.
Again, why? Yes.
Again, white order dated 4/4/2014. Honorable High Court in so and so, the Honorable Court observed, formality required for bifurcation of surrender means number was not complete. So the petitioner should be allowed to operate a fishery in the respective area of composite fisheries.
Petitioners means who? You.
petitioner here is Godadhar. We are.
Yes. Because if your lordship looks into it at page 93, the appeal which was filed is by Godadhar. Kindly see 93, which they have filed an appeal.
Your respondent?
Respondent
Mr.
number
Manna, respondent? 4.
Eight.
What number?
Here I am 8.
8.
In this I am 8. This written.
So, my lord, these bifurcation, certain formalities has to be required. It's required, so it was not complete. But however, my lord, there was some order to allow to operate the fisheries area composite fisheries. To comply with the order, Deputy Commissioner Dhubri informed the Commissioner of Fisheries Demand Surrender meanwhile was settled with so and so on temporary basis. Tenderers for new settlement has been floated. In view of the Honorable Court, there would be no difference allowing the members of parent society surrender mean to fish in the aforesaid mean. Subsequent order of the Honorable High Court so and so, and ask the society confined to the respective fishing area. Subsequently, subsequently contradiction arose regarding a letter dated 28/9/2016, whereas the DRC has forwarded minutes of AGM of Sureswar mean by Soma, whereas society has taken a resolution again decision of Sureswar mean Soma by Samiti, whereas the Godadar mean has already been registered overlapping the non-BTD area operation. To hear BOD of the two board of directors, they were called on 28/12/2016. After hearing both the party, considering the argument the Council of Godadar mean by some matter is sub judice, and also considering the earlier Honorable High Court's order the complete formalities under Section 13 of the Act, it was decided that the DRC Dhubri will within 5 days convene a joint meeting of both the societies who comprise the membership of the composite Sureswar mean by Somai Limited, and then adopt a resolution as per provision of the Act. Compliant action taken report will be submitted to the RC Honorable High Court immediately thereafter. So, my lord, meaning thereby, a meeting should be called to complete the formality under
Joint meeting rather.
joint meeting. Now, this is an order of the Register of Cooperative Societies Act,
Right,
my
right,
lord,
right.
on the basis of an application by my learned friend.
Hmm.
Now, we were at page 100.
Yes.
In pursuance to that appeal, my lord,
Hmm.
we have been informed by senior inspector, my lord will kindly see place 100, on 30th of January 2017.
30th January.
Yes, special meeting of composite Sureswar means Somai. With reference to letter mentioned, I am directed to convey a special meeting of composite Sureswar means Somai within 10 days in connection with bifurcation of Sureswar means Somai Samiti Limited under Section 13 of the Assam Cooperative Society Act 2007, as per order of so and so of Cooperative Societies, Khanapara, Guwahati, passed in CP dated means 18th of January means that. appeal.
You are directed to fix a date.
Yes. That's so and so
So that
photocopy.
where-
Now, these two orders, page 93 and 100, was put to challenge by way of a writ petition at page 101.
By
101.
By-
us, by Sureswar. At page 101.
849.
Yes,
Yes.
849, 2017. This was put to challenge.
Okay.
Basically, the bifurcation is put to challenge. And holding a meeting so that we can discuss about the bifurcation of these two societies. Now, this was put to challenge, and my lord will kindly see at page 102. 102.
Yes.
After hearing the learned counsel of the parties,
Hmm.
operation of the impugn order dated 18/1/2017, which will also at page 93, and 31/2017, page 100. And so is suspended until further orders. So this bifurcation has been stayed by this honorable court, which was put to challenge.
That was not a bifurcation. That was one directed to hold a common meeting to discuss.
For the purpose of bifurcation, because certain provision has to be complied, so far as bifurcation is concerned, my under 13. So what we are saying,
Nonetheless, the court stayed
state, whatever with the state. court state.
849 of 2017,
Yes,
13 to 2017,
yes,
both the orders
were state.
stayed.
Now, when the matter was pending,
One moment.
Yeah.
After hearing 1811
and 30,
uh,
31, 2017,
18/117 and 30/117, yes.
was state. Now, when this was stayed, my lord, when the matter was under adjudication by this honorable court, on 3rd of December 2022, this order was passed, which is being put to challenge,
This repetition is pending.
pending.
All the writ petitions.
So this, that's why, my lord,
That is why I said
I
all
don't
should come
mind,
together.
my lord, there may be a separate, my lord, this is, but what I am on.
No, no, you are correct. We may not agree on you on the merits.
May not, be. I may
But,
also, maybe, my lord, I see, my lord, this is where I have engaged. In those cases, I have seen the last case. So I thought that it would be better to point out.
Mr. Manan, what were you thinking?
Yeah.
That there may not be much merits in 849 tentatively, but there is a stay order and the writ petition is pending. During the pendency of this writ petition, passing of this order would amount to preempting the court's proceedings as well as circumventing the proceedings. We can do one thing. We can have an expeditious
Can I just?
hearing of 849. You're a party there definitely.
Yes, in that.
840 and this we can tag with
My lord, can I
849.
just, can I suggest, subject to, of course, my learning friend also here. So if this December 2022 should not be given effective because of 849.
No, that is
And
that
that order,
Hmm.
that may matter may be hard expeditious as possible because my learned friend
I
is
think
agreed.
fair enough.
That says agreed. 100%, I also feel that's an agreed. Maybe I may not also, I don't know, there is an order of the court. That's why I'm pointing out.
If your lordship permits me, little bit of time, subject to my.
No, no,
letter,
please,
CFA.
please.
Can I point out 2-3 things?
No,
I'm agreed
Mr.
to you,
Manan,
agreeable,
we'll definitely hear you.
yes,
But
only
two,
thing,
two things you'll have to admit that 849 is pending.
yes,
Number one, 849, the subject matter we have seen is 18-1 and 31.
exactly,
Both the orders are under stay.
yes.
Unless the embargo is lifted, whether the authorities will have the jurisdiction to pass any orders, number one.
Yes, that is why I just want to point.
Now let us see whether he is successful in
Exactly.
in the order.
Even if,
Let it be heard.
yes, even if your lordship is both the writ petitions, in that writ petition, these two orders are found to be incorrect. In that case also the earlier decisions taken by the authorities will prevail. Let us set aside both these.
No, those decisions are culminated in 18-1.
No, that is
We are
true.
not
No,
on 31.
13-1, let us take,
31 is only asking them to fix a date. That's a
Yes.
consequential thing.
yes,
But the substantial order is 18-1,
yes.
which is a culmination of all the other proceedings, earlier proceedings,
No, that
on
is-
bifurcation.
That is why I just want to point out this thing, that even if these two orders are set aside, then the earlier orders remain. That is why I want to point out 2-3 things, just 2-3 things. That
How-
I-
no, if-
lordship will hear
no,
both.
if you are
No,
hearing
let
it,
it-
if
let-
18-1 is set aside,
Yes.
how does the earlier order stay?
No, earlier orders were
Survive.
with regard to, first thing is the only abeyance. My case is, what is my case? I was kept in abeyance, my registration. I applied for registration. Just for a moment, if your lordship hear me, just for a moment,
Mhm.
because I will not complicate the thing, I'll simplify it. Because there were some complications here, which was just brought into to complicate the whole matter. They want the whole now issue for themselves. That is only issue. We are not against them. We are the same people. We were there since 75. Now we want that in BTA, non-BTAD, let us do. In BTAD, let them do it. We are not against that. No way, your lordship. Let it be demarcated. We are not against it. The only issue that is, court has all along in the writ petitions as well as in the writ appeals have stated that demarcation, fine, you do it. But at least these people should continue their fishing in their respective areas. That is what I tried to point it out yesterday also. So, lordship, two things have happened. Initially, your lordship, what has happened? When there was a decision taken, that decision I'm trying to show, that is why. Your lordship will kindly go back a little bit. In 2013, let us go back to your lordship page 37. It'll take 5-10 minutes, lordship. After that, both the matters can be heard, no problem. 37, your lordship.
Page?
Page 37, annexure 2. This is the Registrar of Societies passing an order on 23rd of May 2013. Why this was passed? Because there was a BTSD had come into effect. So what, I'll just read 1 minute. With reference to the letters on the subject indicated above, I am directed to request you to instruct the management of Soreshwar Min Samobai Samiti Limited for adopt special resolution in the general meeting, specially call for the purpose of division of the said society and to serve the resolution to all the members as required under section 13 of the Assam Cooperative Societies Act. Further, you are also requested to instruct the management of the said society to submit
the resolution along with all other relevant documents to the Register of Cooperative Societies, Assam, Guwahati for further course of action as required under section 13(1) and 13(6) of the Act. A copy of the letter has been so and so, so and so. So this was asked by the registrar to the Assistant Registrar of Cooperative Societies, Dhubri, to do this. They have done it, Your Lordship, in next page, 39. Division of Sureshwar means Samabhayat Samiti. With reference to the letter on the subject indicated above, I am directed to send herewith the following documents regarding division of Sureshwar so and so within non-BTAD among the respective shareholders. So these are the documents sent forward. Now, Your Lordship, page 40, last paragraph, last two paragraphs. Page 40, what has been done? You are therefore requested to take necessary steps for fulfillment of all conditions under section 13 of the Assam So-and-so Act. Further, you are requested to ensure not to deprive the shareholders from operation of fish mills, mahals under their respective area. This was directed, Your Lordship. And on this direction, Your Lordship, I will just take Your Lordship to page 46, what has been done. An inquiry has been taken. All these issues has been resolved. Kindly see page 46 for a moment. This is a letter of 4/11/2013. This was two persons were deputed by the registrar to look into the whole issue of the diversification as well as everything. Report regarding the division.
Where is the abeyance order?
Lordship,
Where is the captain? abeyance
after
order?
this, I'll just read, kindly take up
49.
49. So please kindly take up 46 so that 49 will be, it will be correlating each other here. 46. 46 is 4/11/2013 here. Page 46. This is the report by two of the officers of the government here. Report regarding division of so-and-so society here. With reference to the above subject, we have the honor to inform you that Sureshwar so-and-so was registered in the year 1975 by registration, taking entire villages of Greater Sahebganj Gaon Panchayat as the area of operation of society. Presently has 56 numbers of shareholders. That, sir, after creation of BTC, a total number of 5 villages, including villages Rupsi, where the society is situated, from the area of operation of the society have fallen within BTAD area. Most of the shareholders residing at non-BTC area raised several complaints before Your Honor, also before the additional registrar, BTC, District Deputy Registrar so-and-so, and the society has fallen within BTC and society has no right to operate any fishery mahal outside BTC. That's to inquire into the complaints. Once he so-and-so Inspector Cooperative Dhubri was engaged from Dhubri, and once is Jitendra Nath Roy, Sub-Registrar so-and-so Kokrajhar was engaged from Kokrajhar. Both the above officers submitted their inquiry reports on 22/2/2013 and 4/5/2013 to the respective authorities. That's, sir, on receipt of the report from so-and-so and so-and-so is forwarded the inquiry report to the registrar, Assam Khanapara so-and-so. Besides above, the additional registrar of cooperative societies Kokrajhar wrote by letter dated so-and-so enclosing the inquiry report dated so-and-so submitted to by Jitendra Nath Roy so-and-so to the RCS Assam for a suggestion to divide the society under section 13 of the Cooperative Societies Act. That, sir, with reference to the above letters, the RCS Assam-wide letter dated 24/6/2013 instructed to divide the Sureshwar Min Samabhayat Samiti Limited. Now, Your Lordship, next page 47. Sri Mohan Buragoy, Junior Inspector so-and-so Dhubri, deputed as observer from Dhubri, and one Sri Jitendra Nath Roy, ACS Kokrajhar, were deputed as observer from Kokrajhar in absence of the in presence of the above two observers. The general meeting on 28/7/2013 was held. A total of 42 numbers of shareholders were present. In the general meeting, as revealed from the report of Sri Buragohai, observer, that chairman of the society as well as the general meeting of Sri Suresh Biswas presided over the meeting and initiated discussion in respect of division of the society in pursuant to the letter of RCS. All the present shareholders of the general meeting dated so-and-so assented to the division, and all the shareholders in animosity adopted resolution by number 1 and divided the society into two mean society. As per division of Soreshwar mean society, out of the 56 number shareholders, 29 shareholders fallen under non-BTAD area and 27 numbers of shareholders fallen under BTAD area. Out of the original of operation of the society, 5 number of villages fallen under BTAD and 22 have villages fallen under non-BTAD area. The management of Soreshwar has furnished 2 separate lists of shareholders, one for the non-BTAD area, another for the BTAD area. List also includes. That's how the Secretary Chairman Soreshwar Min Samaj submitted proceedings of general meeting held on so-and-so to your honor on 5/8/2013, along with the necessary papers related to the division of the society. It is mentioned that Sri so-and-so Dhubri also submitted observation report on 5/8/2013. Sir, as revealed from the record that your honor forwarded the
We have
above.
read this, Mr. Verma.
Yes,
Why this,
ultimately,
why this resolution was recommended,
yes.
but that resolution unfortunately has been
That is-
dealt
that
with
is what
page
I'm-
49.
Yes. Now your lordship will see page 48.
48 we have read. 48 last come to the last paragraph.
Yes, that
They have
there was.
recommended for
Yes.
dissolution of.
Yes. Now what has happened in your lordship? Thereafter, we have already applied for the BTAD and since that earlier resolution of the society was taken and it was divided within the general meeting. And that was informed by this letter and to divide it. So we applied for the registration was given to us. But in this letter, in page 49, the letter says, therefore, the registration of the newly created Mean Samabhay Samiti Godadhar by registration number dated 12/11/2013. It is the date of registration. Is kept in abeyance until instructions come from the Deputy Registrar of Cooperative Societies, Dhubri. Now what has happened? It was kept in abeyance. We came before this honorable court, challenging this kept in abeyance. This honorable court then passed the order. You'll also will find at page 51. This is the judgment of the Honorable Single Judge 21/2014. 20/01/2014. I will not read the first page.
Directed the registrar to resolve the issue.
Yes, directed the registrar to resolve the issue on the basis of the submissions made by B. Ahmed, Learned Standing Council, Cooperation Department submits that having regard to the disputed question of fact involved, it will be appropriate to issue direction to the registrar of cooperatives to resolve the issue upon hearing all the parties involved. In view of the above, this is important. The writ petition is disposed of directing the Registrar of Cooperative Societies, Assam, to resolve the issue raised in this writ petition as expeditiously as possible, but not late or later than 31/1/2014. Till then, Petitioner Society, Godadhar, shall not be deprived from the right of fishing India jurisdictional fishery mohol. So the jurisdiction comes from where? From the division of the society between two. Now the division has been kept in abeyance. We have challenged that. Court said that you resolve this issue. Till then, both the societies will respectively run their fish malls in their respective areas. The court has granted that the respective areas they have to do it. So areas have also been demarcated. But then your lordship, an order was passed at page 54 by the registrar. Actually, I'm pointing out because this was not pointed by my learned friend, as a senior friend, your lordship. Page 55, an order was passed on 19 and 28 March 2014. I'm not reading the first page. I'm reading the operative part, page 55. After hearing and scrutiny of all the relevant records, it is observed that when cooperative society divides itself to two cooperative societies, the society have to fulfill the provision of section 13(1)(6) of Assam Cooperative Societies Act. But here in the instant case, it is seen that the required formalities were not observed and as such needs to be reprocessed. In view of the above, the district registrar cooperative society is directed to start reprocess of the division of the society. Till then, status quo shall be maintained. The status quo remains. We will be fishing in our area, they will be fishing in their area. That's it. That is why I'm bringing the issue before your lordship. Then your lordship will see page 56. Because I want to bring your lordship to the writ petition again, writ appeal. That's why I'm showing this. page 56, Your Lord. This is by the Deputy Commission. Now, the Deputy Commissioner also passes an order. I'll read the relevant paragraph at page 57. Therefore, it is needless to say, if Lordship has gone 57, say that the members of the newly created society, MS Godadormin, who are the members of the parent society servicer, are entitled to fish as members of the parent society in the fisheries without having their separate entity in the name of Messrs. Godadhar Min Samabay Samiti till the process of division of the two separate societies is completed by the Register of Cooperative Societies Assam. So this was here we have challenged this on because what they did, though we are a Godadhar society, we will be fishing under the name of service. This was directed by the Deputy Commissioner. Against that, we filed the writ petition. That writ petition is numbered as 1909-2014. 1909-2014. And in that writ petition, Your Lordship, the court passed the order at page 58. This is the second writ petition by Godard, page 58. Short order. '59 is the order, that is on 4/4/2014. This court has passed the order. In view of, if Your Lordship has got that, in view of the controversy raised in the writ petition, Professor represented by Secretary so-and-so stands impleaded as party respondent so-and-so so-and-so. B. Ahmed Standing Counsel accept notice on so-and-so so-and-so. Here, last paragraph. Hard learned counsel appearing for the parties in the interim prayer, having regard to the impugned order dated 1920. These are two dates are there. So 1923-2014, that the order of the DC, holding that the required formalities towards formation of two separate units were not carried out, and thus status quo should be maintained pending the said exercise. It is hereby provided that the petitioner society should be allowed to operate the fishery in their respective areas of composite fishery. So even here also Godadhar is allowed by this honorable court to be there. It is separation is there, but the procedure has not been finalized. That's the only issue, Your Lordship. Now on the next, Your Lordship, what has happened? Another, Your Lordship, writ petition filed. No, I don't know. Then Your Lordship will kindly take up the next letter, that is May 2014. Here also, this is, I think, the this is the letter issued by the commissioner here. Oh, sorry, to the commissioner by the deputy commissioner. I am not going to read anything in this because
Is the process of bifurcation complete as yet? No.
that was not completed. That was not completed because of the
at this
number of cases.
At this stage, what is the kind of protection you are seeking?
I am not seeking any protection because two things. That in abeyance, Your Lordship, our abeyance was
See,
only-
you have some two orders
Yeah.
which have protected your fishing rights.
My fishing rights have been protected. Now they want that the whole, both the fishing rights of both the societies should be controlled by them. That is what their basic aim is. In that aim, these cases, these issues have been raised. These issues have been brought in that it is not divided, it is not divided. Whenever case is filed, they come up saying that it is not divided. In fact, we filed an appeal before the authority. In that appeal, they have filed, I have annexed the appeal, I'll show that. In the appeal, they have objected that. That appeal was taken up by the authorities concerned, and these orders were passed on the basis of that appeal, not on the basis of this orders of this honorable court with regard to the abeyance. That is why I was taking Your Lordship to that appeal. The appeal was filed, Your Lordship will kindly see, the appeal was filed by Godadhar on 28/7/2015. That is page 62. Why I am saying that we are trying to resolve the issue. And initially the authorities did not do anything. This is what has happened, you know. 62 is the letter by us. Letter by us, your lordship will kindly see, I'm not reading everything, page 64, the last two paragraphs, page 64, last paragraph. Kindly, lordship,
Mr.
will-
Das, even if the abeyance order is intact, then also he has the fishing
No,
rights.
fishing, what I am on,
No, no,
fishing is different. My lord.
He is
we are-
interested in the fishing rights
See,
now.
what is the whole case about is bifurcation.
No, that will,
Today,
that,
my
that,
lord, your
that
lordship
will
kindly
examine.
see the provision of the act.
No, that will examine, that will examine.
13,
But for that, he needs to exchange the pleadings,
so definitely.
interested in the
my lord,
fishing
what I am
rights.
on,
which were
no, what I am on.
protected by the, this
that's
court in
true.
two proceedings.
But the order which are, that should be kept in abeyance, my lord, till it is not being decided. Fishing, let them do it if they are doing it, my lord. We are doing it. But that order should be
Mr.
kept in abeyance.
Manan,
It's a violation, my lord.
Senior counsel is saying something.
Let them do it.
That
whatever.
the issue regarding the registration, which was in abeyance, that will be decided and you're without affecting your fishing rights. Is it okay?
that is always there, your lordship, because
That is
even the
okay. We'll clarify that.
Yes.
and
clarify
your
it.
lordship will clarify, as well as one thing I would pray
clarify.
before your
But
lordship,
this
that,
order should
This
be
will not
kept in
cause
abeyance.
any prejudice to you.
yes,
This
only
will
one
be
thing I
kept
would like
in
to point
abeyance,
out,
my
one
There
thing,
is an order of the court, my lord. How can they pass this order?
Okay, Hartsri did us.
only one thing, your lordship will take this matter along with the
Yes,
other.
Hartsri did us, senior counsel, assisted by Sri DJ Meji. Also Harts. Sri Y.S. Manan, learned counsel for the caveator, respond number 8, full stop. The petitioner has put to challenge an order dated 3rd of December 2022 passed by the Insurance Additional Registrar of Cooperative Societies, by which an earlier order of keeping in abeyance the registration of the respond number 8 has been withdrawn. Full stop. The primary contention of the petitioner is that there is a litigation, there are a series of litigations, including writ petition number 849/2017 in this court, in which this court had passed an interim order in the process of resolving the issue of bifurcation of the two societies, full stop. It is contended that the petitioner society, namely Sareshwar Main Samavai Samiti, was the parent committee formed in the year 1975, and after the territorial division of the BTAD, the respond number 8 society was required to be constituted, the registration of which is yet to be finalized. Full stop. He submits, senior counsel submits that the impugned order would be in the teeth of the interim order dated 13/2/2017, passed in WPC 849/2017, which is still pending. Full stop. Para. On the other hand, the Manan, the learned counsel for the respond number 8, has submitted that in the series of litigations, the respond number 8 had also filed writ petitions, including WPC 242/2014, in which there was a clear direction by this court dated 21/2014 that the petitioner, that the respond number 8, that the members of the respond number 8 should not be deprived of their fishing rights in their area falling outside the BTAD. Full stop. The said order was reiterated by another order dated 4/4/2014, passed in WPC 1909/2014. Full stop. Para. Issue notice returnable by 4 weeks. Government, Sri J. Bodloy, learned Training Council Corporation Department, accepts notice on behalf of Resolutions 1, 2, 3, 4 and 5.
Yes, Lordship. For petition, 4 and 6.
Okay, 3 and 5. Okay. You are also a government advocate. Who's 5 is a, okay, 5.
Seven tomorrow.
Sri BTAD, Sri P. Nayak, Leonard Standing Council, BTAD, BTC for respondable
4, 6, 4, 5 and 7.
4, 5,
4, 6 and
4, 6 and 7.
4, 6, and 7. Sri Manan has already accepted notice for respondable 8. That extra copies be served upon the Senate Council for the respondents. Para. Heard the Senate Council on the interim prayer. Full stop. After hearing, comma, this court is of the opinion that since the orders dated since the order dated 18/1/2017 and 30/1/2017 are stayed by this court in WPC 849/2017, and the writ petition is still pending. Coupled with the other two orders dated 21/2014 passed in WPC 242/2014 and order dated 4/4/2014 passed in WPC 1909/2014, while the impugned order shall remain stayed till the returnable date, the fishing rights of the members
of
of the respondent number 7 society,
not 7, 8 years.
8 society shall not be disturbed. This court is also of the opinion that the present litigation is only an offshoot of the issue of bifurcation, which is already pending in the aforesaid writ petitions mentioned. Full stop. Para. Accordingly, this case along with WPC
First is your lordship.
849/2017.
Yes.
Your petitions are not there. 14, I think they are disposed of.
No, not this one. Both are pending. 242 are still pending.
No, 14 is gone. First one is gone. 242 is gone.
No, 42 is not there. 1909 is.
1909 maybe. And along with WPC 849/17 and WPC 1909/2014. We fix a date.
Up to your lordship.
List
After the bifurcation.
obviously after the list on 27th of 26th of April.
Lodge, this order has been kept in statement.
Yes.
Petitioner before your lordship is my lord, the contractor and contractors association, my lord. My lord, they are senior, my lord, contractor of the PWD, PHA, etc., my lord. And they have, my lord, sufficient work experience, my lord. And they have also done, my lord, some works under Jal Jeevan, my lord, mission, my lord. I have annexed, my lord, in my edition and affidavit there, my lord, the works order, my lord. But here in this case, my lord, violating the, my lord, procedure and or guidelines of the, my lord, Jal Jeevan mission, my lord. Works are, my lord, allotted some of the contractors, my lord, without bidding process, my lord. Even, my lord, I have annexed, my lord, as many as, my lord, 6 works, my lord, have been granted to one contractor, my lord, depriving the petitioners before your lord.
Where is it?
My lord, in the writ petition, my lord, I have annexed, my lord, this work order 24, my lord. My lord, 24, this is justice there, my lord. Then 25 also another work order, my lord. Then 26, then 27, then 28, then 29, my lord. Against one, my lord, the contractor, my lord. On the other hand, my lord, there are, my lord, several contractors are there in the district, my lord.
Yes.
My lord, page 48, my lord, of the affidavit. This is an work order issued in favor of the
You
petitioner.
file affidavit.
No, their affidavit, no, additional affidavit, ma'am. This is an work order, my lord, issued in favor of the petitioner, as was issued in respect of the other private respondents, my lord. His basic case, my lord, appears that, my lord, he's agreed because of
48,
page 48, annex 3, my lord.
Samsul
Shamsul Islam Borbe, one of the petitioners, my lord.
is a petitioner.
Yes, my lord.
Samsul is a petitioner, Mr.
Exactly.
Borbia?
Yes, my lord.
So, my lord, I think, my lord, his basic case is that, my lord, he's not getting as much work as the others are getting, my lord. Because tender is not an issue here, my lord, because, my lord, will kindly see how things are
Sorry, my
processed.
lord, sorry, my lord, this Samsul Islam is not petitioner, my lord, it is, my lord, NS, my lord, one of the contractors.
Who are you? How many of you are there?
My work order, my lord, Samsul Islam work order petitioner 41, my lord. Earlier work order, my lord. Your lordship, earlier, my lord, put a query.
Anyway,
my
It is
lord,
not
whether-
his name is Samsuddin
Yes, my lord.
Borlos.
Yes, my
Yes,
lord.
my lord, because I
Page 41.
my lord, earlier occasion, when my lord, he has bid ID, my lord, in the order, my lord, reference to, my lord, his bid ID is, my lord,
9295.
9295,
This is not petitioner.
he is petitioner, my
Petitioner
lord,
number
This 48 is not petitioner.
41 is petitioner, my lord.
41.
41 is petitioner. I'm sorry, my lord. He's the petitioner number 3. But what I was contending is that, my lord, he is also the beneficiary of the same process. His basic case is that, my lord, he's not getting as much work the others are getting. If my lord,
Samsuddin,
this is one of the order issued in favor of him, my lord,
yes.
as was issued in respect of the private respondent.
Petitioner 3,
Petitioner 3, my lord.
yes.
If now, my lord, there is a space 54, my lord. These are all MPNL contractors, my lord.
Hmm.
And this was a tender, first table, my lord.
Hmm.
Left hand side column, my lord, last one, tender title. Package 0 for fixation of rates for different items of PWFS. So, my lord, rates are fixed in a bidding process. Then, my lord, works are allotted as per the SOP. So what I, my lord, feel, my lord, that if the petitioner is aggrieved for not getting much work, he can definitely approach the authorities. If he is capable enough as per the SOP, my lord, he will definitely get, my lord.
Now, the works are distributed on what basis?
That is the SOP, my lord, in the writ petition, page 18,
1/8.
1/8, my lord.
SOP is of which date?
But this is our SOP, my lord.
In 2022. my
Page
lord.
17 is the, my lord, decision of the cabinet.
Have you put this to challenge?
No, my lord,
No,
he is
no,
also
I-
getting orders under this SOP, my lord.
Because, my lord, page 18, clause 11,
Okay,
my
well,
lord, it is provided that, my lord,
Alright.
there-
3 AM Board here, Senate Council for the petitioner who, by means of this petition, has expressed his grievance of unfair practice in distribution of works under Jal Jeevan Mission amongst the empaneled contractors. Full stop. It is by drawing the attention of this court to various work orders, the Learned Council has submitted that orders have been passed in favor of few contractors by which the petitioners are deprived. Full stop, para. On the other hand, Sri E.N. Goswami, the Learned Additional Advocate General Assam, appearing for the water resource,
PhD department.
the Public Health Engineering Department submits that the works are allotted by following the SOP as published on 19/10/2022. And by following the said SOP, even the petitioners, within bracket petition number 3, petitioners following the same SOP, it appears from the documents annexed, that even the petition number 3 was a beneficiary. So para,
No, not beneficial.
you had got the work
My lord,
once.
my lord, it earlier, my lord, I have done, my lord, I am, my lord, eligible. So, my lord, experience, as per this, my lord, I have to given work, but it is not given, my lord.
What is this then, your work order?
It is of
Well,
2020, my lord.
20, my lord.
So
My
he
lord,
has
Only to
perhaps
show,
got it under the earlier SOP, my lord.
yes, my lord.
Piece of
Only
land,
to show, my lord, the
piece of land, piece of land, lekhibha.
bid ID, my lord.
Yes, yes. Huh? Para, the issue raised would require some deliberations. Put the para. Issue notice returnable by 4 weeks. 3 Osami. The learned counsel for the department accepts notice on behalf of
1 to 9, my lord.
as per numbers 1 to 9. Extra copies be served upon him by tomorrow. Steps for service of notice upon the as per numbers 10 to 15 PO2, be taken by registered post with AD. Steps by tomorrow.
My
Take
lord,
steps by tomorrow.
my lord, till there, my lord, status quo may be
My lord,
maintained, my lord.
works are being,
Just regarding what?
My lord, this work, but otherwise, my lord, they
my
will
lord,
go
works
with
are
their
being
work.
implemented for,
These are matters of public importance. We'll examine the issue. 4 weeks, you have said.
Otherwise,
Correct.
if my lord, final work order is given, my lord, matter, it will be infructuous.
This is not pertinent to one work. These
My
are
lord,
schemes.
my lord, prima facie, my lord, one person, my lord, given, my lord, as many as, my lord.
The work has already been granted. He is doing or she is doing.
No, my lord, I have stated, my lord, it is not doing, my lord.
Not at this stage. We'll see. Yes,
Correct.
next.
Otherwise, my lord, lordship matter will be infructuous, my lord. No meaning, my lord.
Instructions we cannot help.
then, my lord, may I suggest, my lord, let him file a
We
representation.
cannot help.
Then I will file representation, my lord, till then, my lord, work order may not be implemented, my lord. That matter, my lord, dispose of, my lord. Because otherwise, my lord,
We have praised for an interim order for seeing the works in question, full stop. The works being of public importance, this court is not inclined to pass any interim order at this stage, full stop. The prayer, however, may be renewed after obtaining of instruction.
oblige, my lord.
Wait, Mr. Lordship. This matter pertains to me. Lord. We sought some information under the Right to Information Act. Yes, Lord.
Third,
Possibly they will give it me, Lord. 11 days. 11 days. End of the day.
We'll dispose it of only concern is that RTI was filed in a central government department. As a state commission, we don't have
pertains to
the,
what? Central government or state government?
the information, except two questions, everything else pertains to central government. So only with regard to question number 3 and 4, which is apparent from the records, we'll dispose of only on that part.
What I am on is that in the zone before this honorable court, they realize only the 11 days delay whatsoever. Delay being going on, the matter goes back, they pass it out appropriately, whatever his stand is. That may not be reflected here. That's all.
But Lordship will kindly see
Art-
place.
Correct.
Art 3 as Onik, Learned Counsel for the petitioner who is aggrieved by by a communication dated 2/11/2023,
January, 2-1.
2/1/2023, by which his second appeal
Lordship.
filed under the Right to Information Act has been rejected on the ground that the same was barred by time, full stop. The Learned Counsel has submitted that the delay is only 11 days and
And may I rephrase my submission, Milo? Initially, it was 11 days, which they regretted by the order at page 22, saying that you're not stated grounds. Thereafter, however, granting us the liberty to file again. In filing again, it took about a year or so, the COVID time was there. But again, they by cryptic order, they regretted. What I'm on is that delay being 11 days initially, a lenient view could have been taken, disposed of, whatever on merits use.
sorry. That the second appeal was preferred within with
11 days.
we preferred with a delay of 11 days, which however was directed to be explained. And in that process,
Process.
due to the intervention of the COVID,
COVID.
comma,
Some delay.
some more time was taken by the petitioner. Full stop. The learned counsel, however, submits that the delay, period of delay has to be construed from the date when the first, from the day when the appeal was preferred. Full stop. He further submits that the delay not being inordinate, comma, the same could have been condoned and the information be afforded, be provided to the petitioner. Full stop. Para. 3. D. Deca, learned counsel, standing counsel, Information Commission has submitted that though on principle he may not have objections in the prayer made, comma, he submits that out of the queries, comma, only one query would be only 2 queries would be pertaining to the state government, and the rest of the queries would pertain to the central government, of which the state government cannot be made responsible. State Commission cannot be made responsible. Full stop. Para. Responding to the same, comma, Bonig, the learned counsel for the petitioner, submits that for the present he would be the petitioner would be satisfied if the queries pertaining to the state government, state commission is.
What I want, delay part be gone. Let them reflect them in the order. Let them reflect them in the order.
No,
without any
delay,
order from the lordship.
we are taking care. Delay, we are taking care.
So the rest part may come in their order. Subsequently, we'll follow.
Yes, yes. No, we are only on the state commission salary. For the present, he would be satisfied. The petitioner would be satisfied if the queries pertaining to the state commission is provided. Full stop. Para. In view of the broad consensus arrived at in the bar, comma, instant repetition is disposed of by directing the second appellate authority to consider the second appeal of the petitioner without insisting, by conducting the delay of 11 days and pass necessary orders on unnecessary speaking orders on the state appeal. Full stop. The same may be done within a period of, what is the statutory period? 1 month.
There is no statutory period for second.
Within a period of 45 days from the date of receipt of certified copy of this order.
In this matter, I'm appearing as a legal aid counsel.
As Boni, counsel, counsel appearing as a legal aid counsel. No, not counsel, as Boni, appearing as a legal aid counsel. Yes.
My lord, my senior is on legs in another court.
Yes, Mr. Secretary.
Lordship here, the petitioner applied for the settlement of the land of his father's property, and accordingly, it was processed, and the subdivisional level advisory committee, after scrutinizing all these documents, it was approved, and thereafter, my proposal was sent to the government, revenue department. And the revenue department subsequently, after considering all these proposals, returned back saying that your this premium, you calculate the premium properly and send back us again. And accordingly, the deputy commissioner enhanced the premium from 30,000 to 45,000 as per the existing value of the land. And accordingly, it was sent back again to the government. Then the government, after about 4 years in 2018, again sent back the proposal saying that some of the report and documents, it has not been sent.
Yes,
and-
so what do you say? You take instructions, will issue notice. R3 B3, Learned Council for the petitioner. Full stop. It is the case of the petitioner that 8 lechas of Sarkari land under Dag number 199 of Tilapathar Nagar under CC Borgaon Revenue Circle in the district of Dhemaji was under the possession of his father, is under his position till the time of his father. Full stop. There is a process which has been initiated for settlement of the land, in which there has been intra-office communication. Full stop. However, the same has not been finalized. Full stop. Para. Issue notice returnable by 4 weeks. MS S. Sharma, Learned State Council accepts. Revenue. MS PR Mohanto, Learned Standing Council Revenue accepts notice on behalf of respondent number 1. Whereas MS S. Sharma, Learned State Council accepts notice on behalf of respondent numbers 2 and 3. That extra copies of the writ petition be served upon the Learned Council for the respondents by tomorrow. Yes, next.
Lordship, my senior is on legs in court 1.
Who is your senior?
Yeah, Mr. UK Nair. Could
What-
the matter be?
what
passed
is
over
the
to
matter about?
pending?
Yes.
Matter is about what?
Asharani Brahma, court 1.
Private respondent,
Respondent 6.
Mohila Sunil. Notices is yet to, I have not yet moved it.
And what is the matter about?
Well, there was an order from this court that initially what has happened, my IMFL shop was at in Rajgarh. Then it was shifted to my lord.
Where are you specializing in IMFL shops? There are other business also. I think you
Just
should,
like Mr. Goswami on the other
you
side.
should, I think you should upgrade to milk booths.
I'm not only IMFL, I'm into electricity also.
And milk booths, Purabi, Amul,
Or some fitness center.
a fitness center, yes.
Yes, sir.
That's your forte,
Yes, sir.
not fashion,
No,
not fashion photography.
or CrossFit.
Only thing I have noticed, my lord, in last 21 years, my lord, because
Status
maybe
quo.
because of the fitness center, he has been able to maintain status quo only.
That's also good.
It's not status quo. He is becoming younger. It's the reverse status quo. Yes, what is this?
Well, you'll also see the last order of the Honorable High Court at page 55 is the operative statement. Paragraph 8.
Yes.
On considering the fact there is nothing to show that there is any illegality in the running of the IMFL shop by the petitioner, this court does not find any reason not to allow the petitioner to open his IMFL shop. Accordingly, the respondents are directed to allow the petitioner to open his IMFL shop immediately. The petitioner shall, however, visit the office of the Deputy Superintendent of Excise, Kamrup Metro, within a period of 10 days from the date of from today with a copy of this order and a copy of the writ petitions. Besides the above, the respondents are directed to ensure that the further action that may be taken upon the petitioner by the respondent upon the report to be made by the GMC should be preceded by then, my lord, after
This
that.
was on 21/11/2022.
Yes, madam.
What has
After
happened
this,
thereafter?
madam, what has happened is before 21/11/2022, my shop was initially at Rajgarh, then it was shifted to Atigaon Bonful Road because Rajgarh Road was widened. So some local Mahila Samiti had filed a complaint, my lord. And on the basis of that verbal complaint and all those things, my lord, they closed my shop. Then I came before this honorable court. The honorable court passes this order. Then the shop was open. Then, my lord, a so-called notice because some liberty was given in that order. So a so-called notice was issued, my lord. You also will find that page 57.
So You've seen it.
Yes, madam. Now your
You
lordship
have
will.
shown cause.
Madam,
Have you shown cause?
show cause, madam, what is the show cause, madam, your lordship? will
No, have
only-
you shown the cause? Yes, you have.
Yes.
62.
Yeah, my lord. In the show cause, my lord, in the page 57,
Hmm.
after 7-8 lines, your lordship will find. In the report dated 9/11/2022, the deputy superintendent of excise found that in terms of rule 225 of the Assam excise rules, so and so, there were altogether 24 neighbors within 75 meters from the shop premises, out of which 6 neighbors have objection regarding opening of the shop, and 18, in the report, it has been mentioned that 18 are in favor. Now, further queries are made by the circle officer, Dispute Revenue Circle, as well as from the additional commissioner, Guwahati Municipal Corporation, regarding the status of the permission of the building as well as the land. Consequent thereto, the Commissioner, Guwahati Municipal Corporation, in his report dated 6/12/2022, informed that the Guwahati Municipal Corporation approved for a RCC G+3 building for residential use, and the ground floor was approved for parking. From the NOC for construction issued by the GMC, it reveals that the NOC was issued in the name of Obhijit Roy Hatigao. From the report dated 27/1/2023, submitted by the circle officer, Dispute Revenue Circle, it is also revealed that the land in question is mutated as
The
Malu in the name
private
of so and so.
respondent is represented, Mr. Nair.
Nair represents the Mahila Samiti who has filed this complaint. Your lordship will find the complaint in page number, my lord. Complete the code of.
Now the order 23 to 2023, what is this?
Now what they are trying to say, my lord, what has happened, the premises,
What is the status now?
my lord, they are not renewing my license and they are trying to stop the operation of this. They are asking me to shift it from that location. Because, my lord, what has happened, the building where my shop is located, the back side is a residential building, and in the front side commercial, there are 2 shops. Out of the one shop is mine and the other is some other person. The GMC, NOC and all those things are, the landowner name is there. Building permission is the name of the person of other person. Against that, my lord, there are civil suit that will take its own.
Is
course.
the shop open or?
It is open.
It is open as on today. And my lord, your lordship, if the GMC has say, for example, if I, for a moment, if I presume that my shop has any NOC problem with the GMC and all, or I have there some dispute, my lord, GMC will take into, of course, its own action. But so far, excise is concerned, my lord.
Let Mr. Nair come.
Yes, your lordship will kindly see the complaint of Mr. Nair at page
You
46.
take instruction, let him continue.
My lord, he will continue. Difficulty is that my lord will kindly see page 69, the last part of the order, my lord. It is, or accordingly, it is ordered that licensed premises of Sri Shankar Kelta bearing so and so, presently situated at so and so, before it shifted to any other location that conform to any norm, all the norms regarding location of a shop, or else appropriate steps would be taken for closure of the shop. We are not taking any steps for closure. We have allowed him, but he is not in taking any steps to shift, my lord. He cannot run in that property, my lord, because he has basically cheated us while, my lord, applying for, my lord, he has committed fraud on us, my lord. Well, page 33 for a moment.
Oh, you have a problem with the location.
No, not only location, my lord, the premises.
How do you reconcile your problem with the earlier order of this court? Court says that everything is okay.
No, earlier order court said, so if we do something, it has to be preceded by a notice.
Okay.
So that is why we have given.
That you have already said.
That we have already done.
What is the problem here?
Page 33, my lord, will kindly see for a moment.
3.
3. It was a deed of rent agreement. It was submitted to us, my lord, while asking for shifting permission, my lord. It was a deed agreement executed between, my lord, will see Sri Mrs. Omiya Gogoi and Sri Shankar Kelta. Shankar Kelta is the petitioner. Omiya Gogoi is the
Owner of the.
owner of
The land.
Then, my lord, will see.
Of course.
Page 38, my lord, will see tenancy agreement.
Yes,
He produced this agreement before us, page 38, Omiya Gogoi and Shankar Kelta. Based on this, my lord, even, my lord, he misrepresented, I don't know how he could got an NOC from GMC. My lord will see at page 44, my lord. 44. This was an NOC that he submitted to us while asking for shifting.
Yes.
GMC granted him NOC for operation of that shop in that premises. Terms and condition number 1, NOC is valid for 1 year only from the date of issue. But when we received the complaint, we caused inquiry through the circle officer, so through the deputy superintendent. We asked for report from circle officer. We asked for, my lord, report from GMC.
What was the nature of the complaint?
Nature of the complaint initially was location, but what we could found, my lord, page 61. Page 61, it was a report given to us by GMC.
You want.
With reference to the above, I would like to inform you that the no objection certificate for building permission which was submitted at the time of application for trade license in the name of so-and-so, IMFL off from Deputy Commissioner so-and-so, situated in so-and-so, Guwahati, was approved for RCC +3 building for residential use, and the ground floor was approved for parking. This, my lord, was along with this, my lord, GMC give us an NOC for building permission. My lord, kindly have a look at this, my lord. My lord, building was.
You want to contend that the building was never meant for commercial purpose?
Three grounds. It was not, NOC was not for Omiya Gogoi, it was for Obhijit Roy. My lord will see that NOC. Building NOC, my lord. The tenancy agreement should have been executed with Obhijit Roy, my lord. Whatever dispute, we don't know, because the NOC says it is Obhijit Roy. Serial number A, my lord will see. Proposed use residential. My lord has got it back. Then my lord will see serial number C. Number of floor, ground floor, first floor, second floor, third floor, and DF, handwritten, ground floor parking. And that parking lot, my lord, he has started his shop, my lord. And it is not us only, my lord. This time also GMC will also not grant them any NOC, my lord, because that NOC has already expired. He has completely, my lord, suppressed all these things, my lord, misled us, committed fraud on us, basically, my lord. That's why, my lord,
Which Obhijit Roy?
there is a dispute about the land, my lord, between Obhijit Roy and Omiya Gogoi. But this NOC, this building was constructed by Obhijit Roy on the basis of this NOC, my lord. So a tenancy agreement, irrespective of any dispute, has to be executed by Obhijit Roy with the petitioner, and he cannot operate in the parking lot of a plot, my lord.
No, Obhijit Roy may be a power of attorney also.
Builder.
No,
Obhijit Roy is the builder.
There is
a
a
civil
dispute
dispute
between
going.
the title over the land, my lord, between
And it
Obhijit
is
Roy and Shankar.
And
Omiya Gogoi.
and it is reflected in page 63, the report of the circle
He may
officer.
be a tenant of Omiya Gogoi also.
Yes.
Assuming, my lord. Then, my lord, residential purpose and
Ah,
ground floor
that-
is for parking.
We are not on the, whose name the NOC, but you may be right in contending
Residential purpose
that the purpose of the
is residential and
construction
ground floor is for
is-
parking.
ground floor is not for any commercial purpose.
Exactly, my lord. We have simply said he can shift to the any nearby location, my lord. But he is adamant, my lord. He, my lord, waited for a month, my lord. Now, because the renewal time has come, my lord, he has approached this court. My lord, kindly see what was the reason, my lord, we have said. Page 68 for a moment. That's the order imprint, my lord. It is of 23rd of February. Now 23rd of March, my lord. These are the 1, 2, 3, 4, 5. These were the, my lord, grounds. Reasons in the cited in the NOC, my lord, sorry, so cause notice. He replied. Then, my lord, how we applied our mind, last paragraph, my lord, whereas on 17/2/2023, an unsigned reply. His reply was also unsigned, my lord.
What is the answer to 4 and 5?
4 and 5 answered, my lord.
4, mainly 4.
My lord.
Regarding the permission for
My lord, my lord.
only for parking and
Page 66, my lord.
66.
Or serial number 4, my lord, down below. Now, regarding the use of the building and the space allotted for parking, those can be ascertained by Guwahati Municipal Corporation tax receipt, where the uses type is mentioned as C, commercial. And the parking space at the ground floor can be seen left vacant from the photograph attached here with, my lord. Some part is vacant, my lord. He has NX photograph.
No, we will not go by the marking of C.
Yes, my lord.
If we have the NOC.
Exactly, my lord.
If the authorities say that it's not commercial.
My lord, let him give an undertaking, he will start the process of shifting, we'll issue him, my lord, here. Let him operate in this place, my lord.
Let him conclude, my lord.
Till, my lord, his proposal for shifting is finalized, my lord. Let him operate from this place. We don't want his shop to be closed, my lord. Otherwise, we could have processed for that also. Let him operate, but he has to go, my lord.
I think yes, fairly yes.
My lord, what I'm.
Your continuance in this place, I think would be slightly dicey.
No, my lord, that your lordship will kindly see the report of the circle officer at page 63.
63.
Yes, ma'am. মানে বর্তমান জমি স্থিতি সন্দৰ্ভত শ্ৰীমতী অমিয়া গগৈ স্বামী তৰুণ গগৈ আপোনাৰ শুনছন দেন সেকেন্ড প্যাৰাগ্ৰাফ নথি মতে বেলতলা মৌজা হাতীগাঁও ফেৰাজ মিয়াদি নম্বৰ 4 উপৰোক্ত ব্যক্তিৰ স্বামী
তৰুণ গগৈ পিতাই বীৰেন গগৈৰ নামত এজমালিত নামজাৰি চলি থকা দেখা যায় নথিমতে উক্ত দাগৰ জমি ব্যৱসায়িক ঠাইৰ জমি হয় ইটস এ কমাৰ্চিয়েল ল্যান্ড প্ৰকাশ থাকে যে স্থানীয় তদন্তক্ৰমে উপৰোক্ত জমিত মহামান্য আদালতত গোচৰ চলি থকা বুলি জানিব পৰা যায় জমাবন্দী সংলগ্ন কৰা হ'ল
No,
there is
the-
already a
the-
dispute pending
the
between
class
the
of
owner.
the-
This is not the
Sir,
correct, my lord.
for the class of the land is not the issue.
Yes,
It is the building
Yes,
for which the permission was granted. Was it granted for a commercial purpose
No,
or for residential
my lord,
purpose?
the building that is which is G+4 they are talking. It's in the backside of the shop. In the last occasion also, we have submitted the photographs in this because this issue was raised in the last round of in the last week petition, we have given the photographs.
So if you dispute that, it's your burden, the onus will shift upon you to produce the NOC for the building which your shop is there,
Yes.
which is for commercial purpose.
Yes, ma'am. Madam,
You produce that.
Yes, madam. May I pray, my lord, today? My lord, let this matter be fixed immediately after the.
Tomorrow, my lord, instead of getting passing an interim,
It
order, let it
will
be
take
tomorrow.
some time to get the papers.
Then on Monday,
Immediately after Bihu, because they also said that I should take the step for shifting and all if I don't find those documents. It's fair enough. So allow me to operate till Bihu. Immediately after reopening of the Bihu, I'll apprise this court, then this honorable court will pass the consequential order. Let me operate till
he
Bihu.
can operate till the process of shifting goes, but he has to start it, my lord. Because admittedly, my lord, ground floor was for parking.
Well, without prejudice to any of my rights, my lord, I-
Council.
if necessary.
Assisted by
Yes, Nandi.
S. Nandi. Learned counsel for the petitioner. The petitioner.
My lord,
Yes.
lordship. My lord, it was on my complaint. They had come to me for filing a KVA.
I think your duty has already been done by your.
That is, my lord.
We don't find the NOC in for commercial. We are not going into the ownership, whether Omia owns the property or Abhijit.
Lordship.
But he is raising another question that the NOC which has been referred to you by you or Mr. Goswami pertains to another building. And no, he's saying a building on the backside.
Lordship.
That is his contention. And we have said that in that case, the building which you are occupying, you produce that NOC, which shows it is for commercial.
Lordship.
Otherwise, I'll start the shifting process, my lord.
Only thing, my lord, he can do is, my lord, the ladies there. My lord, the license,
No,
whatever he
we
gives,
are passing a balanced order, don't worry. You know? Petitioner, he is presently running a business of an IMFL of top on the strength of a license issued to him in the year 2001. The shop is presently located at house number 22, One Full Pot, Hatigao Road. Full stop. The petitioner is aggrieved by an order directing him to shift the shop order dated 23/2/2023, to shift or relocate his shop, full stop. Para 4, the learned counsel for the petitioner has drawn the attention of this court to an order dated 21/11/2022 passed by this court in WPC 7434/2022, in which this court had recorded its prima facie satisfaction on the running of the business in accordance with law. Full stop. Issue notice returnable on 26th of April 2023.
holding number, John. Holding number.
P.N. Goswami, learned
There's no-
Additional Advocate General, appearing for the Excise Department, accept notice on behalf of so numbers 1,
1 to 5 minutes.
2, 3, 4, and 5. Whereas MS, what is your name, Adam?
Miss D. Mohanto, my lord.
MS D. Mohanto assisting the UK and Ireland Senior Counsel, accept notice on behalf of number 6. full stop, heard the learned counsel for the interim prayer, full stop. The Sri 4, the learned senior counsel has submitted that the impugned order has been passed without any application of mind and by overlooking the relevant factors. Full stop. On the other hand, Sri Goswami, the learned additional AG, Assam, submits that the premises on which the business of the petitioner is presently running is not authorized for any commercial purpose. And in this regard, he has produced before this court the no objection certificate by the Guwahati Municipal Corporation granting building permission, which is for residential and parking only. Full stop. He has also raised the issue of the validity of the rent agreement which the petitioner has annexed by stating that, by submitting that the NOC is in the name of Abhijit Roy, whereas the agreement is with one Srimati Amiya Gogoi. Full stop. Para. The State Council submits that when the building in question is not for any commercial purpose, comma, there is no infirmity or illegality in the order impugned, and the petitioner and full stop, he further submits that the action is a very reasoned one whereby only the petitioner has been directed to shift, and there is no other coercive action for stoppage of his business. Full stop. The Sri Nair, senior counsel for the for number 7,
Malad 6, Malad.
6,
Here,
submits that the entire issue has arisen from a complaint made by the respondent, by his client, and there is a legal infirmity apart from the other social causes in running the business from the present side. Full stop. After hearing the parties and on consideration of the and on balancing the equities, comma, it is submitted that till the returnable date, though no coercive action be taken against the petitioner, comma, it would be the duty of the petitioner. No, responding to the same report, to record the senior counsel submits that the NOC which is being mentioned by Sri Goswami pertains to another building, and the
except building.
to another building, and the premise where from which he is running the business is actually for business purpose.
Malad,
And the NOC for and the NOC for the premise from which the business is being run is for commercial purpose. For the Sri Core is accordingly directed to produce necessary documents in this regard. Balancing the equities by no coercive action be taken against the petitioner, comma, the petitioner is directed to produce the NOC for the building from which he is running the business to substantiate his contention that it is that the NOC is for commercial purpose. Full stop. It is also made clear that the petitioner is at liberty to explore the option of shifting to any other location as permitted in accordance with law.
And my, till my shifting, they are not, they will not renew my license. My license renewal, they are stopping it. So till the next step, they will not,
No coercive we have said. We are not saying any independent positive thing.
This plot of land, my lord, the agreements that he have entered into, my lord, therein in page 34, just read one line, my lord. What is so and so in respect to commercial room measuring 375 square, including sufficient parking space, 5-6 numbers of cars parking space. One, that and the NOC numbers are same. My lord. Then the tenancy agreement,
Let him produce. We are not saying anything.
it's the same building.
on record,
Understood.
it's the same building.
Same building.
Understood. Let us.
If it is not there, why your lordship has indicated, I will look for the possibility of shifting to a nearby
Yes.
building. My lord, my friend has now started taking a course in makeup to assist. Mr. Uni has taken up a course in makeup to look fair and assist.
There's some change in his.
The only complaint with the, this.
We see
one
some
line-
change in his
No,
complex.
no, my lord, the only complaint with the, this is, I'm not seen, my lord. Online.
I'll not respond in live streaming, my lord. We will talk outside. my lord.
Even if we do not see Mr. Nair, we always hear him loud and clear. Okay.
My lord,
5 minutes.
next date, my lord.
We have given a date. 26th of April.
Deeply honest.
Much obliged.
Now 5 minutes.
Rules. Now, so far as the license fee is concerned, presently the government is sanctioned for a renewal. But difficulty is the insisting on payment of the establishment charge. And our stand is 60 lakhs what they're claiming, and our stand is for a particular period, the entire operation was suspended. It was not in operation. In that view of the matter, the authorities are taking a twin view. The first view is that if they go for waiver, then I need not pay. But if they do not go for waiver, then subsequent course of action, I pay, I do not pay, that's all. For the present, I'm aggrieved by the order at page 28, the communication rather, at page 28. May I read that?
License is existing or not?
Existing. Existing. So page 28, they say, you pay up the license fee.
You
and-
say that the establishment charge should be waived because you are non-functional at that time. That is your main contention.
That's one condition, but they have to take a call on that. Now, if they take a call and they cross over the 31st March, by operation of law, my renewal goes and my license ceases. So may I pray, whatever payment I am to make, whether I make or not, I suffer the parent and the consequences. So regardless of this establishment charge, that demand, they may consider my renewal is granted, that's no problem. Only thing is that establishment charge may not be insisted as on date. They may take a call, independent, they may take a call.
For that period.
And before that, may I just indicate one thing?
When is the last date?
31st March,
31st March.
31st March. By the close of March, I'm gone.
Can you see the page 25?
So see, renewal and cancellation are different connotations.
They would have different meanings
No, no,
if I do not
they-
pay.
See, if they may not renew, but that doesn't mean that their license has been cancelled.
May I then,
We can say that the
130.
option of renewal, we'll have it open.
130, Miller, 130 of the excise rules, if I just read out that part. The licensees who fail to deposit the license renewal proposal as per.
Those
rule
for
one-
the excise department.
is-
Repairing.
For renewal and his favor has been delayed due to reasons attributable to licensee. And if for such reasons, the licensee failed to deposit the license renewal fee as so and so, the license shall cease to have effect with from the first.
That
of
is
April.
ceasing to have, that is a different condition because of non-renewal. Non-renewal may not be of any malpractice or any allegations.
May I invite my notes attention then to,
No,
I understand.
your license can be cancelled also if you are not abiding by the conditions or some malpractice.
Here says license fees, non-payment of license fees.
So that is not an allegation. It is only a consequence of non-payment of the establishment fee. We'll keep it open.
But they have kept it this way, Miller.
As pay as
If
Bonik.
lordship takes up page
To
26. for
protect your interest to some extent.
Lordship.
As Bonik, Leonard Council. for the petitioner who runs a distillery in the name
MS Himalayan Distillery.
of
Private.
Messrs. Himalayan Distillery. Full stop. The petitioner claims to have been provided a license in the year 2004-5 and renewed from time to time. Full stop. The case of the petitioner is that from April 2020 till October 2022, the factory was inoperative mainly due to the COVID intervention by COVID. Full stop. However,
COVID is not a lot.
no, 2020,
Not because of COVID. Some other
mainly have said,
maybe some other reason also.
mainly for April 2020. And other reasons also, COVID. However, without taking that into consideration, it is the case of the petitioner that the authorities have raised a demand of rupees 60,39,201 as area establishment charge. Full stop. The petitioner has approached the authorities to waive the same. So, however, instead of taking
The waiver prayer was for rupees 31 lakhs 80,632, 3180,632.
for waiver of an amount of rupees
31
80
632.
632.
for this period.
So why have you written 6039?
No, that is the
Entire
demand.
period lordship.
That's the demand. We say out of that 31 lakhs odd, the factory was not in operation. The establishing part is not even required for that under the rules.
And it's not proper presentation. Area
demand was-
demand of rupees 60,39,201, which includes the current charge.
No. It includes 60, includes everything.
And what is this 30?
31 is the inoperative period. The establishment charge may not be levied for that.
That is it. 60 includes the present charge also.
Absolutely.
Yes.
That is what we are saying. Which 60, 39,201, which includes the period when the factory was inoperative, which amounts to which is for an amount of rupees 30.
3180
62.
632.
3180,632. Full stop. That's what Pisor Khini ahi jabo, approached but the petitioner, but the authorities have not paid any heed to. Full stop. The petitioner also apprehends that on the ground of non-payment of the area establishment charge, the license which will expire on 31st of March 2023 would not be renewed. Issue notice returnable by 4 weeks. N. Goswami, Learned State Council,
Standing Council.
Standing Council Excise Department,
For 120 lordship.
accepts notice on behalf of respondables 1,
2 and
2, and 3. Whereas the distillery, Learned State Council accepts notice on behalf of respondable 4. That extra copies, not done. Heard the Learned Council for on the interim prayer, full stop. While it would be open for the authorities to consider the application for
Waiver.
application on for waiver of the establishment fee or cost fee
Charge.
or establishment charge for the period when the
April 20.
factory was inoperative, the license may be the issue regarding renewal of the license may be taken up,
The government already
Provided-
reported sanction. Page
provided,
27.
provided the petitioner pays the balance amount,
Admitted amount.
balance amount, apart from, balance amount, for the period when which, on which, for which the factory was operative.
Lordship, petitioner give the assurance that if whoever was not paid, he will pay the entire amount. Lordship, case 25. Lordship.
That will decide,
That will be solved.
that will decide. Yes, how?
Before your lordships, grocery shop owner, my lord.
Grocery shop.
My lord, they had a trade license also, my lord.
Hmm.
But I mean, my lord, during the month of June, my lord, 2022, my lord, they had purchased, my lord, a total 2,304, my lord, of bags of rice, my lord, from Ma Mansa rice mill, Jagi Road, my lord. And those rice were kept at a Sunari godown, my lord, under location PS, my lord, in the Gwalior district, my lord. Suddenly, what happened, my lord, on 9/6/2022, my lord, the superintendent of the consumer affairs, my lord, potential supplies, my lord.
No, if the items are auctioned,
My lord.
what prejudice will you suffer? Tomorrow, if you are able to establish your case, the sale process will come to you. These are perishable goods.
My lord, that is why, my lord, they had, my lord, earlier the court had rejected, my lord. Finally, see, my lord.
Now, unless the issue, whether you would be, would be given Jimma or not, would be
My lord,
decided. The goods are getting damaged.
My
So if
lord,
it is auctioned, at least the amount would be safe, secure.
my lord, kindly see, my lord, what they are doing, my lord. Kindly see page 42, my lord.
We have seen that.
My lord, 42, my lord. Here, my
Why
lord,
you are grieved?
the, my lord, court had earlier, my lord, the respondent also never ascertained, my lord. They have could have never ascertained whether those of PS rights or not, my lord. PS rights or not, my lord. Even, my lord, they are,
See, that dispute is not been decided.
my lord. And
Now to decide the dispute, when was the seizure made? Tell us.
my lord, the seizure was made, my lord, on 11/7, my lord.
Yes,
11/7/22, my lord.
2011-7/22.
My lord.
Almost a year.
My lord, we have already submitted our resignation, my lord. We
Now,
have
now,
never
now,
heard, my lord.
now, suppose
My lord.
it takes more time, and in the matter, every day passing,
My lord.
the articles are getting damaged.
My lord.
Instead of, if you are successful in your endeavors, then the proceeds will come to you.
Indeed, my lord. I will appreciate that, but what they are doing, my lord. I listen to the court order,
So
my
what
lord.
order do you want today?
My lord.
Don't go for auction.
Yes, my lord.
This court will take a conscious decision, let the
No, my lord.
articles be
At least-
damaged.
At least, no, my lord. For few days, at least they could have disposed of my representation, my lord. Without hearing my representation, without availing my any chance, my lord, to substitute my claim, my lord. Can you see there is existing order of this court on also, my lord. Case 42, my lord. The disposal of the application is being filed
Where?
by the petitioners. Case 42, my lord.
No, 44, 44 also there is an order.
Yes, my lord. That was submitted before the along with the representation, my lord. That is same order, my lord. They are 44, my lord. They are. Where read, my lord. Till the
Where is the representation?
Then
Where is the application?
45, my lord. Case 45.
And what is the subsequent order? You had to get bail also what?
Yes, my lord. I think the case was registered, my lord. We
Yes,
had
there's an order, Mr. Dury,
impune auction order is
that
65.
you should not go for auction without considering the application. What have you done? Page 42.
Yes, your lordship, please. Yes, your lordship. Till disposal of the application is being filed by the
Now,
petitioner.
it may be a case that the application is actually being disposed of. He is not
May not be
highlighting.
aware, may not be
May
aware.
not be aware, may not
May
be
not be aware.
highlighting. You take
And, Otherwise also,
you take instructions.
since
and-
the auction is on 24th,
Tomorrow, my lord.
tomorrow. So I shall have a telephonic conversation and to give the dispose of his representation, given answer to his query.
No, no,
It may
see-
be positive or negative as per law, it has been said.
There are two, there will be two situations.
Yes, your lordship.
One is that his application has been considered disposed of.
Yes,
to which he is not aware,
Yes, your lordship.
or maybe his clients have not informed him,
Yes,
number
your-
one.
Yes, your lordship.
Number two, giving bona fide to him
Yes,
that the application has not even been considered.
yes,
In that case, the impugned order will be in violation of page 42,
yes, your,
which you cannot.
yes, your lordship.
So what we'll do,
Yes,
we say that you put your notice of auction in abeyance
yes,
till such time when you get the instructions whether his application was taken up for disposal or not. Okay?
in
We
case,
can have it on next Monday.
yes, in case the same has not been made,
Yes.
made,
Hard,
that may be recorded.
yes. This is item number
32.
hard three as hoc alternate counsel for the petitioners who are aggrieved by by a notice for auction sale dated 13/3/2023 for certain goods, price, which were seized from the petitioners with the allegations that those are PDS price, full stop. It is the case of the petitioners that they had approached this court on an earlier occasion by filing criminal revision petition 520 of 2022, in which there is an order dated 3/11/2022 directing the petitioners to approach the Deputy Commissioner Gwalpara taking custody of the seized goods, and in the event such approach is made to dispose the same in accordance with law. So it is further provided that till such disposal of the application, the seized rice shall not be auctioned, full stop. The learned counsel submits that the application dated, what is the date? 45? 5/11/2022 is yet to be disposed of,
By the deputy.
and yet the auction sale has been and yet the notice for auction sale has been published, fixing tomorrow, full stop para. Let the learned state council obtain instructions as to whether the application of the petitioner before the Deputy Commissioner has been considered and disposed of. Let the matter be listed for motion again on Wednesday next.
Yes, sir.
On 29th, 29/3, full stop. It is however made clear that till the next date fixed, the notice for auction shall not be proceeded with.
Dated 15 March 2020.
15 March, dated 15 March 2022 shall not be proceeded with.
If the application of the petitioner has not been considered.
I may not say that, he may not be aware. You bring the instructions, have that disposal order with us, then it will clear this.
Obviously.
Okay.
You have that, if it is disposed of, get the order also.
Yes.
We'll record it and dispose.
Yes.
Mazumdar?
My lord, before your lordship, against the notice dated 5/1/2023 lordship, by which lordship authority declared for acquisition of land for the extension of the national highway number 306 in the district of Kachar. Thereafter, within the statutory period, we made an objection, and that was considered by the authority till then. But when lordship in this case
Consider, not consider.
not considered, hearing was not taken place, and on the other hand, lordship from the 0% that is from Silchar, Rangpur lordship till the house of the lordship, house of the petitioner.
What is the present status?
Status lordship, only notice issued, declaration not made, and our representation was not considered lordship by the.
See, these are the nature of compulsory acquisition. You can file your objection, but if it is needed for a public purpose,
Lordship,
and you'll be entitled
but,
to
Lordship,
compensation.
we are not for that. Actually, in the whole area, it was widened in both the side of the road. But in front of our house, it is a Lordship depopulated area and built up area. In that place, Lordship, it is made one side. And it was acquired 100 feet only in our side. Keeping that side, no land was acquired.
These
from
are
the
all
opposite side.
matters of experts. We cannot say which way to go, which not way.
Lordship, but
Only thing is that there should not be any malefic excesses of powers. If
Lordship,
they can
that-
explore
that-
another
that-
option of, we issue notice at this stage.
Lordship and
Third, 3 LR Muzumdar, learned counsel for the petitioner, who is aggrieved by a notice dated 5/1/2023, by which the petitioner has been informed regarding acquisition of his land for construction of a national highway under the scheme of Bharat Mala Sarak.
Right.
The petitioner contends that without acquiring the land of the petitioner, the developmental work can very well be done, as there are ample land available
in both sides.
on both sides. What's the para? Issue notice returnable by 4 weeks. MS, MR, CGC, your CGC.
No.
CGC. MS CKS Burwa, Granite CGC, accept notice on behalf of respondent number 1. NHIDCL, madam,
Lordship.
I'm as the VL Singh, standing counsel NHIDCL, for respondent number 2. Whereas B Deori, and State Council, for respondents 3 and 4. That extra copy of the petition be served upon the.
Lordship, my house may be, for the time being, that may be status quo. House may not.
No, we are not touching now.
Lordship,
Land acquisition process.
127 feet. It,
আমি কি returnable কিটা কৈছো? I will give a date. Returnable on on 19th of April. Come up with instructions.
Lordship, during that period.
Acquisition
may not,
proceeding of national
Lordship,
importance, we are not touching. Sorry.
Lordship, otherwise we have no objection. If it is done at the extent of Lordship 70-80 feet, that will no way cause our damage, Lordship.
Land acquisition proceeding, you don't have much say. You will be entitled to compensation. If it is needed for public purpose, if it is done bona fide,
That is
interference is minimal.
Lordship, that can be done by the other side also, Lordship.
Next.
Right.
Ready? Yes, what is this?
Small prayer, Lordship, the date of the murder, the land vested on the petitioner, Lordship. While he is going to pay rent, he found that in the land record, his name is omitted. He filed an application before the deputy commissioner. Notice was issued thereafter. It was the record in the office was not traceable. It is pending at that stage from 2020 onwards. Lordship. Still, it is pending before the. First, you will find.
What do you want in this petition?
I want direction to the respondent and deputy commissioner as well as circle officer. They have taken up the matter to trace out the case record and to proceed to its logical conclusion.
Is this a matter of judicial review?
Lordship.
To trace out records?
Because the executive authority cannot left a process in the midway.
Have you, why don't you go file a representation before the higher authorities?
They cannot, Lordship, because
We are here to examine decision-making process, not finding some.
If the authority derail, admittedly, they have, this is the case number, Lordship will find.
Now, if a situation arises
Yes.
that in spite of the fact the records are not there, they are taking a decision against you, then you come to us. Now for this limited grievance, you cannot come to
No,
a
Lordship,
court
we
of
will-
judicial review.
No, Lordship will find.
What is the
this
decision which you are aggrieved? What is the decision?
It is not the decision, their inaction, Lordship.
Inaction
Lordship,
in what?
I have a right to get the
Whom have you
logical
gone?
conclusion. It
Thereafter,
may be in my favor, it may against me.
thereafter, whom have you approached?
Lordship,
Records are not there, whom have you approached thereafter?
no,
who-
this is a proceeding initiated before the office of the deputy commissioner and the circle officer is taken up. That is Ms. J case number 641 1920, Lordship. This is the registered number, case number. Now they are not accepting the hazira, nothing. They have simply stated that the record cannot be traced out. The process cannot be derailed in the midstream. It has to
So
come to a
that-
logical
That
conclusion.
will make your doors open for a writ court.
Yes, Lordship, this can be. Because I have the Lordship, their obligation is,
We will not concur with your.
their
your
obligation,
understanding.
Lordship will hear me, their obligation is to give the logical conclusion and I have a correspondingly, I have the right to get
See,
the
it's not,
result.
it's not a case that they are holding back. You have a specific case that the records are not traceable. Have you approached the higher authorities?
The higher authority is the deputy commissioner, Lordship.
Where is your representation?
Representation is not there because in the same office, we have time and again approached them.
Where? Let's see,
Statements are there, Lordship.
not do. Approach the deputy commissioner. If he doesn't do anything, then come to us. Records are not there. What can a writ court do?
If
We direct for tracing of the record.
Lordship will.
Is that our function?
No, Lordship. What I am saying, they cannot derail the process in the midstream. They just,
You have specified the reason. It's not a derailing. They are not proceeding because their records are not available. We are
Then-
not saying
then-
that you are remedialess.
no,
You approach the deputy commissioner. You approach the commissioner in the government, that this is the state of affairs, what are you doing? What is the decision which you are assailing in these proceedings?
it is
Is there a
question of,
decision?
it is not, Lordship, it is not a question of challenging anything.
Then
It is a
are we here
question,
to do administrative jobs?
Lordship.
Then, sorry,
Lordship,
Sorry.
let it be on Friday or any other day. I will argue, Lordship.
first you have the on record some kind of representation before the authorities. At least we can direct them to explore on it.
After Lordship.
You know how to frame a reputation. This is not how to frame a reputation.
The registration of miscellaneous case.
You want a direction to trace out the records.
No, Lordship, what I am saying, do the needful and to give its logical conclusion. To bring the proceeding to a logical conclusion. My prayer is there.
You cannot be so vague. You filed representation, you did not come before us.
No, Lordship.
That might
after
give you
it-
some handle.
What I am submitting, Lordship, after registration of a.
If you are not understanding what we are saying, giving you the leeway, we could not help. Bringing what logical conclusion? The records are not there.
Then-
What kind of orders
then-
are you
then
expecting?
what
Tell
is
us.
The ways and means the
What are
officers to do it.
Have you approached them?
Yes, Lordship, I
Where
have.
is the representation?
Lordship, even.
No, the representation.
His representation is recorded if a registered
Okay.
case number, case record has been, very strongly go-
We have given you enough.
Lordship will
Let's say
fix
you
it
do-
on some other day, Lordship.
We are dismissing it.
Lordship fix it some other day, I'll show Lordship. Because we
Fine.
have a right.
Actually, Dr. Learned Counsel for the petitioner who has approached this court with the grievance that the case records in mid-J case number 641, 2019-20, which is before the learned. Who is the authority?
It is filed before the deputy commissioner, Lordship, and taken up by the circle officer.
Before this learned circle officer, Guwahati Revenue Circle, Olubari, is untraceable. First stop. Prima facie, this court is of the view that the present challenge is not against any decision-making process wherein the powers of a writ court can be exercised. At this stage, Telephonic conflict raised for some time to obtain instruction. Stop. List on Monday next for motion.
May I please your lordship? Lordship, petitioners before your lordship are the shareholders, my lord. Okay.
Are the
Shareholders of the.
shareholders?
Shareholders, my lord, of Kekata Cooperative Society Limited, Bhupakhana.
Hmm.
My lord, here the case of the petitioners are that on the petitioners, a notice was issued by Assistant Registrar that elections are going to be held at Annexure 1 on 24th.
For the board of directors.
For the board of directors. And as such, my lord, the existing board of directors, they have notified through one voter list on 28th of February in the notice board. After getting that on 1st of March, we have made an application that provide us the voter list. And as such, they have provided us the voter list on 3rd of March. After receiving the voter list, we could find that, my lord, in the voter list, there are as many as 200 dead persons and 332 persons are, my lord, unknown shareholders who have left those villages.
We have dealt with similar matters. We have dealt with similar matters. The anomalies in the voters list.
My lord. And
Election is tomorrow, my lord.
my lord, my lord, that is what I was going to place. My lord, on 3rd, after receiving everything, we have made on the day of nomination was 14, my lord. On 13,
You have your rights under the act.
my lord,
We cannot intervene in election.
my lord, as per the act, the first voter list has to be prepared. My
There is
lord,
an embargo. You cannot prevent an election.
my lord,
We have passed numbers of orders. Mr. Talukdar,
Consistent order, lordship.
do you have an order copy?
Those orders I don't have, but your lordship has said that election would not be interfered. The remedy is under rule 27
my lord,
of the
there-
election
that is
rules.
what I- my lord, only one submission I will make in this regard. The 14 was the date for nomination, my lord. On 13 itself, we have filed an application before the register, before nomination, everything stating the facts. On 13, we have made, again on 14, we have made, continuously we have been making, even on 20, we have prepared ourselves this chart amongst the voter list, which I have annexed, reflecting that 187 has already died. Out of the voter list, 332 persons are, we have prepared this chart, we have given to them for the easy convenience to be held. I have annexed everything.
Where are the rules?
2019 rule, my lord. Rule 27.
Election rules of 2019, isn't it?
My lord.
Third,
My lord,
I must, yes.
my lord, here, with regard to the rules itself, my lord, one more submission is that, my lord, the rules itself also provides that the voter list by rule 3H, my lord. 3H, it provides that for the correction of the voter list, my lord, if anomalies are found, and it is given to the president and the secretary to correct it, my lord, by the rule 3H of the rules, my lord. And by the Act of 2007 also, my lord. By the Act of 2007, by 26 subsection 3, it also provides that once it is notified the voter list, they can approach the authorities, my lord. The shareholders can approach the authorities if any anomaly is committed. My lord, from 13, that is prior to nomination, till this 20, we did not want to approach this honorable court for this reason. We have approached the registrar, assistant registrar with multiple representations. And my lord, till 20 of this month.
What do you want now? Tell us.
My lord, there are anomalies in the voter list.
What do you want?
My lord,
We are not saying what is there. What do you want?
my lord, the election, my lord, in the voter list where itself it is anomaly, my lord, they to stay, my lord, we have prayed for that.
We are not staying in elections. That is against the mandate of law. Elections are not meant to be
My
stayed.
lord, we have made, there are.
It will be your whatever grievance you have will be redressed in accordance with law.
My lord, we have made applications before register, my lord. Till 20, my lord. no action has been taken. We have
Maybe,
given.
maybe you should have come earlier.
My lord, the law, the mandate says that, my lord, my lord, may I read the provision, my lord?
Can elections be stayed?
My lord, that I am aware, my lord.
Then if you are aware of making that submission, have you read the provision of 329B
My
article?
lord, that I
What
am
is it? What is the spirit of 329B?
What?
Where is the Constitution of India? The process of election is a sacrosanct process.
My lord, I,
You can question only if the elections are over. That is the spirit. Read what is 329B. See the wordings.
my lord, I am
Have a
aware.
look at the say,
Lord, I am
article.
Lord, the submission is that to this extent at this stage, but my only may be recorded so that after that also I can.
Your application will be treated to be a petition under 27. That much we can say.
My lord, that would also
And
be there.
27 says 3 days. Even if you want a liberty, 3 days you can still, or if you say that your existing application should be treated, we can say.
My lord, that can be done.
See the workings of 329B. Or MS SG Burwa, Learned Council for the petitioners, full stop. The petitioners who are 4 in numbers are shareholders of the Kerkata Cooperative Society Limited, Bukakhana, in the district of Lakhimpur. Full stop. The elections for the Board of Directors have been notified, fixing tomorrow.
My lord,
Tomorrow. The case of the petitioners is that on publication of the voters list, they could detect that there were a number of persons termed as shareholders who had passed away. And there were persons whose antecedents were not known. And therefore, therefore the petitioners allege that the elections were sought to be held on the basis of an incorrect voters list, which will not give a proper result. The Senate Council therefore submits that while the matter may be examined, the elections scheduled tomorrow may be postponed. The SK Talukdar, Learned Standing Council, Cooperation Department, however, submits that there may be substance in the allegation of the petitioner on the factual aspects regarding names of dead persons or unexisting persons, the redressal would lie by invoking the provisions of section 26, right? 27.
27, Rule 27.
Rule 27 of the Assam Cooperative Societies Election Rules 2019. Full stop. At this stage, the counsel for the petitioner, Ms. Barua, has submitted that representations are already pending for the appropriate authority. Full stop. In view of the above, and taking into consideration the provisions of the rules, this court is of the opinion that the demands of the petitioner can well be redressed by taking into consideration section 27.
Rule 27.
Rule 27 of the aforesaid rules. Full stop. It is accordingly provided that the representations which have already been submitted may be treated to be an election petition. Full stop. The petitioners are also at liberty to submit press petition before the election authority within the period specified, that is 3 days for redressal of the grievance. Full stop. In the event, in any case, the representations which is pending or the application which may be filed are required to be disposed of expeditiously and within a period of, and preferably within an outer limit of 2 months.
2 months.
2 months from the date of receipt of such application.
Obliged.
Also like me.
No?
My lord, in this matter, we were directed to
Yes, yes.
place a status report. So they say that the petitioner has not been found in any police station in West Khasi Hills, Monga police station. And there is no identification papers available from for the for her PAN or for her Aadhaar. And according to this, my lord, the conclusion is that the petitioner does not exist from this status report.
The easy way is to close this, but with closing petition without saying anything else, this I think that will not be proper. Mr. Council, you have a lot of responsibility.
My submission is your lordship.
You'll have a lot of questions to answer.
My submission is to your lordship. It is a general practice that is from all places. They come to the place where the High Court is.
No, we are not.
No, my submission is this.
Your submission, we are not we are not the appropriate authority to consider. We'll send it to the appropriate authority.
My submission is this, your lordship. I am an arguing counsel. I have been engaged only in the court to represent the matter. It was.
Mr. Council, you are not understanding.
It is not a
Those
petition.
submissions of yours, we cannot say yes or no. It is
No,
for
no.
an authority.
It is on record.
It is, you have to go to an authority. We'll
Your
send it to an
lordship-
authority.
Your lordship, my submission is, it is on record. The other counsel, that is, this is a brief from the other chamber. And it has been admitted, it has been all, that is the other.
Mr. Kalsi, can we go into those aspects? Bar Council of India, Bar Council is there, Bar Council will take up your matter.
Your lordship, it has been accepted by the council, that is, it is.
They'll accept there in the Bar Council. This is a very serious matter.
This is a serious matter.
We're not saying anything against you or in favor of you.
Your
Prime
lordship,
Minister will say that
your lordship, mine is whosoever has drafted the petition knows the petitioner.
you give your explanation.
This is my humble submission.
You have signed your
No, think
Wakalatnama.
this.
Or
That
you have
is-
any other submissions to make? It can be,
Submission is this, your lordship. It is a general practice. That is, we are engaged. only-
again, we are saying. We have found something prima facie which is very, very serious. It has to be looked into. We are not here in exercise judicial review to look into these matters. There is a body special. We'll refer the matter to the other matter.
As it pleases your lordship, that is my humble submission.
That is the
It
minimum we have to
general
do. We
It's
cannot leave matters of this kind. Just closing the matter. After 6-7 years, suddenly we are confronted that there is no
Your
person
lordship,
like that of the petition.
I have appeared several times. I have submitted, that is, I am not receiving any instructions. And regarding this one, it is on record. That is, this is a brief from the other chamber. And direction was given to Mr. Devajit Goswami also to appear, and he has admitted.
Whoever is there on records, the proceeding will be against all of you.
Indeed, my lord.
Whoever is there on, we are not
He has
singling,
been admitted.
we are not we are not singling out anybody. Those who have signed the Wakalatama, they are answerable.
Your lordship, who has, that is, it was, it is not my drafting.
How do we know?
It is the advocate clerk who is presented, and moreover, the advocate clerk is not mine. It is on record. It is Goswami is a advocate clerk, and this is the CID's report also.
Can you go into the facts of the case? Can you go into the facts of the case?
It has been.
Advocate's clerk will only identify the person at the time of signing the affidavit.
It is the
Wakalat
advocate
nama you
clerk.
have accepted.
It is the advocate clerk and the
Have you read
others
what is, have you read the contents of a Wakalat nama?
I understand your lordship.
No,
I
not
don't-
understand. Have you read or not?
I've read it.
Then what is this kind of submission?
Your
You take
lordship,
full responsibility. We are not
regarding the
still,
Wakalat
still we are
nama,
saying, we are not saying anything. We are referring to the bar council.
regarding Wakalatnama, your lordship, this is a judgment of the Supreme Court.
Also.
Your lordship, this judgment may kindly be taken note of. This is a judgment of the Supreme Court. It is regarding the Wakalatnama.
You convince the authority, not us. We are not saying anything. We are not saying anything. Yes, what is this?
This is regarding anomalies which takes place in the Wakalatnama, and it is a general practice which has been observed by the Supreme Court also. That is, people from the small districts, they come, they engage lawyers in the big cities.
It is a case where the petitioner was a
It is
non-existing
regarding
person.
anomalies regarding the Wakalatnama.
Non-existing person.
It was regarding Wakalatnama only, your lordship, regarding defects being found in the Wakalatnama. And it has been observation, and moreover, the Supreme Court has said, that is, as the IDs are not there, the High Court can frame its own guidelines, directing that is in future, that is how the Wakalatnamas are to be filed. Like in trial courts, ID cards are asked, Aadhaar cards are asked. Those things can be implemented, your lordship.
We'll pass orders. We are not touching this matter. We are referring to the bar council. Is it your petition? Is this your petition? If you have any grievance, you file a petition. You are a respondent here, I think. We are closing this, referring to the bar council. That is it, the bar council will see. Or that the CID case, police case is on, that is yet to be culminated. We are not saying anything on this. We are not causing prejudice to any of the parties. Law is taking own course. We are only what prima facie appears, we will pass on. Next.
I'm only allowed to file a affidavit. I'll file an affidavit regarding this one.
You find your, we are not saying anything against you, Mr. Kalsi. We are only referring the matter to the bar council against the persons who have signed the wakalatnama on behalf of representing a person who is not existing. That's all. That's all. Next.
During pendency of this petition, the petitioner died. Now, IA has been filed by the wife for substitution.
What is the subject matter?
Well, the eviction notice was issued to the petitioner, my lord, who were living there since 1965, my lord.
Is there any interim order?
Yes, my lord.
Third, and a Kalita, Third Council for the applicant who has filed the connected IA for substitution of the writ petitioner in the connected WPC 683/2020. It is the case of the petitioner that the original writ petitioner Basanta Das is her husband who had instituted the writ petition against the order of eviction. Full stop. He further submits that there are interim orders protecting the rights of the petitioners. Full stop. Colita, the learned council submits that on
38/2021.
38/2021, comma, the original petitioner Basanta Das has expired. And since the right to sue survives, comma, the present application has been filed to substitute Basanta Das by the present applicant. Full stop. When did you file it?
I have filed it July 2022, madam. 18th July 2022.
And when did he pass away?
August 30th August 21.
Not, not
29.
within time.
Yes, my lord,
Hmm?
yes, not time, my lord. But there are some delay, my lord. I have stated in paragraph 4, my lord. Ordinarily.
Considering, though there appears that there is, you must have, for whom?
I'm for the private respondents, my lord.
Is anything you want to say?
My lord, actually, my lord, he is occupying the government land.
No, not on merits,
Just in front of my.
not on
property.
merits,
I
not on
don't have any
merits,
right there,
on
there.
substitution, let him be substituted.
My only prayer, my lord, we have offered them that since you are occupying a government land in just blocking
No,
my road. please
first
give them
let us dispose of the substitution application, then on the, once he substituted, then we can consider your case. So there is some delay. There appears to be some delay in filing this application for substitution, comma. Considering the subject matter and in exercise of the equitable jurisdiction, comma. The instant I is allowed. Stop accordingly. Registry may take steps, is not me, registry is to take steps to replace the name of the original petitioner Vasanta Das by the name of the applicant. What is your name? Nilima Das.
Nilima Das.
Nilima Das. In the cost title of the accompanying WPC 683/2020. I accordingly stands disposed of. In the writ petition you write, in view of the order passed today in IA 2142/2022, comma, registry is directed to make necessary corrections by replacing the name of Vasanta Das by his wife Nilima Das in the cost title bola na upar, in the cost title. That the writ petition be listed for, it is admitted.
My lord, it is not admitted.
Sri M.K. Boro, Learned Counsel for the private respondents, however, submits that the matter require expeditious disposal. Puts the para, list the petition for admission immediately after the bifurcation. Okay?
My lord, date may fix, my lord.
Tell us the date. On 21st of April.
My lord.
Obligation.
M.K. Boro, Counsel for the private respondent, as well as the state respondents, as well as counsel for the state respondents, do not object to the substitution in principle. Cooperative. Hello, Mr. Yes, anything?
My lord, it is that, my lord, Rani Tea Estate, my lord. Where, my lord, we had tried to trace out the records and records were lost, but as has been certified by the civil judge number 2 for this honorable court. After making a thorough inquiry, my lord, the court.
We already have some records which have arrived in the court.
That is the, my lord, mutation record which we had applied, my lord, before the deputy commissioner Kamrup, my lord.
Yes.
But what happened is, my
Now
lord.
we can have for admission hearing.
Yes, my.
If you're ready, you can have it today. After?
My lord, there are only two aspects to be considered. Kindly, my lord, please, it will not take so much of your lordship time, my lord.
Mr. Chaudhary is appearing or you are appearing?
My lord, my senior is right now on legs. That's why I have to.
He'll be appearing. Tell us a date.
He did my.
21 matter.
After vacation.
Can it be before Bihu vacation, my lord? If
G. Chaudhary, Learned Counsel for the petitioner submits that the matter would matter requires expeditious consideration and disposal. Full stop. P. Bharadwaj, Learned Counsel for the private respondent, however, submits that that the matter can be taken up for admission hearing on admission after the Bihu vacation. Full stop.
Let it be before that, my lord, on 12th, if your lordship.
On 12th.
11th or 12th.
Those days will be the motion days. I'm submitting for his benefit.
No, not for.
We have it on 20th, Thursday, on 20. 24. Please. Yes.
All right.
May I please, your lordship? Lordship, item number 10, 8 to 10, my lord, petitioner has mentioned the matter,
Yes.
but they did not inform us, my lord.
No, you have been informed.
No, my lord. They did not inform us, my lord.
Mr. Jayab, or we had asked him repeatedly. He has gone and again come back. He has said that I informed Mr. Datta even. We have, he prayed for taking it after bifurcation.
Lordship.
If you are having a difficulty,
No, my
to bring
lord.
him, we'll change the date
After review.
after bifurcation. Much. But if he's around, ask him to come. This is not proper. We repeatedly asked him. Yes, next. Next.
But 11, my lord, that royalty matter. But I am raising an issue of maintainability, my lord. This for maintainable. I'll show my lord that 2, my lord, if it's already.
Okay, 2 o'clock. After this, we'll have admissions in the supply list. I have. Supply admission, R. Sharma, then oil. Orders probably will not be during time. Orders probably will not be having time.
I have item number 14, then the date may be fixed for that, my lord.
He'll give dates because there are 2 admission matters
I understand.
which there's a request for upgrading. We have not upgraded, but after these matters, Mr. R. Sharma's matter is there and the oil matters are there. Good. Those will take time.
On 6th of April, item
I'll
number
give
14.
that, let's see first.
Lordship,
Come at 2, let us see the position.
Lordship, with regard to the
Item
item,
14, 6th of April.
item 32, your lordship, the PDS auction matter which is scheduled tomorrow, your lordship. If the order gets online, somewhat better.
Yes, we will try.
Yes.
My lord, order
13.
this is order 13 serial number.
Yes.
Tomorrow it will be taken up by.
You be here, we'll try to have your matter if you're around.
Okay, I'm here, my lord.
You come from Shillong, isn't it?
Yes, I have come from.
We'll try to have it.
Well, item number 12, my lord, I have.
No, you're there at 2 o'clock. Don't do this. We're not rising.
Okay, much obliged, much obliged.
And my lord, this is a matter pertaining to contract, mega structure, Sobansiri Dam. There is stay order, we have filed staycation application. So, my lord,
Mr. Bora, where is he?
we'll inform him, we'll inform him.
When do you want?
My lord,
No, it
next
has
week,
come up.
Thursday,
It has come up for orders because there's an IA.
but my lord, since pleadings are complete, my lord, entire matter.
If
can
you,
be
if you are
placed.
insisting that the entire matter can be heard,
Yes,
we
my
don't have any issue, but it's a 23 matter.
lord, but since it is contract, my lord, it's a, because flood control measures, my lord, have to be undertaken. In fact, it is pertaining to building of the embankment in the river. So even the locals are protesting, the work has to start, flood is around the corner.
If we both the parties agree, then probably we can fix a date.
Mr. Bora was agreeable, in fact, my lord, on the last occasion. So, my lord, could it be, my lord, next week, Thursday, on 30th, 30? I'll inform him. Pleadings are complete.
Ask him to come to the court.
Bora, kindly.
Okay. Once he comes, you.
My lord. In fact, he is ready. He told me that.
No.
He says that he's got an objection regarding the maintainability of the report.
Maintainability.
Yes,
My
yes,
read will
yes, yes, yes.
And what about the other, the appeal which has been decided by this court? No, actually.
Your expression was that as if you heard for the first time, maintainability.
No, I was shocked with maintainability. My lord, maybe my learned friend has every right. But what I am saying, well, if your lordship decide about a maintainability, he goes with him. then it should be referred to a larger bench, because this is a division bench, same case has been filed. How can now in a single bench, with great respect, I am saying maintainability can be raised. Something different has to be there for raising maintainability. But similar, exactly on the same point. And that has already been decided by this court. My lord disagrees with.
But how do you reconcile the two judgments of on this issue? Two division bench,
Durga, my lord, completely different. My lord, I'll just show it, my lord. I'll distinguish. I have gone to the judgment, my lord.
My
concept is. Let me complete because my lord.
If he's raising a maintainability question issue, then we'll hear him first.
Yes. But my lord, maintainability point, my lord has to say that this case is totally different with the.
No, we have not, we'll take a decision only after hearing you.
My decided by this court, exactly the same party, same department. Let them say.
Or you can, if you, on the, since he is serious on the aspect of maintainability, if you think that you want some other day, you can have.
No, I don't know what my learned.
That is, his, we are also slightly.
Affidavit listening. This is not taken all this.
That is, we are also slightly caught by
Taken a
surprise.
preliminary objection also regarding maintainability of the case. Preliminary objection has to be there regarding maintainability of the case. He has not taken.
My chance
This is
for
not a law.
addressing the court today is my chance, my lord.
No, no,
Other days, my lord,
No, Mr. Gogoi, you are not precluded from raising a law point, but you have not indicated earlier.
Yes,
It's only a question of having a fairness in the
yes,
court.
yes, my lord. Is because,
We'll do one thing.
my lord.
We'll, Tuesday, you,
let them file a short application. Why is the
no,
petition? And how it
you
will
argue
be-
on maintainability, we'll record something today.
My lord.
Though the issue of maintainability of the writ petition has not been raised in the pleadings exchanged, comma, D. Gogoi and Pending Concept Forest Department submits that there is a point to be urged, which perhaps, if decided in favor of the department, will not require the court to enter into the merits of the dispute. Full stop. 3D, thus, senior counsel for the petitioner, on the other hand, submits that the point of maintainability was never raised before.
And it has to be raised on the first point.
Never raised before, and therefore, some reasonable time be allowed to the petitioner to resist the said prayer. Full stop, para.
So they have to-
Resist, to answer to the arguments that may be made by the department. Full stop, para.
Are they filing an application, my lord?
Not
They
like
have
it.
to. Maintainability. They have to narrate why this petition. Normally, your lordship,
Well, in
when
brief-
maintainability matter comes, preliminary objection.
No, see, but we are not going strictly by the CPC where preliminary issue needs to be framed. Here is raised that issue. Let us see. Will Tuesday. Let the matter be listed for admission hearing on Tuesday, date 28/3. You are here on 28?
I'm sorry.
Are you around on
Yes,
20 on 28/3/2023? On which date the learned counsel for the respondent department would address the court
Yes.
on the maintainability issue.
Obliged.
Maintainability, I was just, the lordship is saying what maintainability. Yeah.
Look, I was just doing some research. What I
No,
found,
that's
the
good.
remedy sought is, my lord, is a private remedy. For 226, well, element of public remedy must be there, my lord.
Very nice. Then I am now, I know. Public law remedy vis-a-vis private law remedy.
Mr. Bora has given the consent.
Mr. Bora,
He has given. And he has sent it junior.
he is making a request for taking this matter for admission, hearing,
Lordship.
for final disposal. Are you,
Okay,
when?
next Thursday, as per the convenience of the senior
Next
counsel.
Thursday.
30th, 30.
It is submitted by the parties that instead of the IA being considered, comma, the writ petition itself can be taken up for final disposal. Full stop, para. Has agreed to list on
30.
30 for admission hearing.
Lordship, interim order is there, Lordship.
Oh, yes, it will
Para,
come.
interim order passed earlier to continue to the next date of listing.
Also, Lordship, learned senior counsel Ken Sodhari will appear this matter. As you can you record his name? He is on another court, Lordship.
If he is not there, we cannot.
Publish.
And today his presence is not necessary.
Lordship.
Lordship has dealt with the issue, my lord, in another writ petition. That is concerning the, my lord, the LOI that had been issued by the IOCL, where I have, my lord, submitted.
Lorry, tanker,
Tank lorry, my lord. Yeah, my lord, in the-
affair, same case over.
Same issue it is with regard to the, my lord, the fixed vehicle against which, my lord, some allegations were there in the writ petition. That the tank was fitted after the, my lord, the explosive license was issued. But there are some allegation against other vehicles for which, my lord, the inquiry was conducted through the DTO and the explosive authority. And, my lord, so far as, my lord, my vehicle is concerned, the IOCL was directed to produce the explosive license and other, my lord, documents.
I was for the ISL,
But
IOCL
here
is a
IOCL
party,
is
my
not a
lord.
party.
not a party.
It is not a party,
Lordship,
my lord.
before my learned senior start, Lordship, may I produce a order of this honorable court, the ISL matter case. Lordship, kindly a flag mark portion.
Application which is passed on the stable.
Yes, my lord. Already this honorable court has interfered with the use of this vehicle number is this petitioner vehicle. The Paragraph 11, my lord.
This is not that case, I think.
Yes, this is their case, and we have suspended their certificate till the final verdict of this honorable high court, my lord. This case is still pending before this honorable court, my lord. Paragraph 11, my lord, kindly have a look. This is the vehicle number is written in this paragraph.
Yes.
My
You're
lord.
correct.
Same one, that's what I said, my lord, the Lordship has dealt with the matter earlier, my lord.
Now what can
Now,
be done today? Tell us.
No, my lord, here, the whole thing is that, my lord, in the order dated 9/12/2022, my lord, your Lordship will find it page 65. 11 portion page 70, my lord,
70.
70, my lord.
Yes, please.
My lord, paragraph 5. The DTO Kamrup M. Sri Gautam Das as well as the MVI Kamrup Sri Amulya Borua, who were dealing with the matter in respect of the vehicle number AS01 NC 8864 are present in the court along with records. From the records, it is stated that at the relevant point of time when the vehicle was registered, it was in the form of tank lorry, but subsequently without following the due procedure of law, the owner of the vehicle changed it to some other form. As a result of which the photograph are available on record of the vehicle not to be in the form of tank lorry. The DTO Kamrup to take appropriate action under law and the vehicle shall now be subject to such process of action being taken. The IOC will also take notice of the aforesaid aspect. Well, pursuant to this direction, my lord, this paragraph 6 direction, they have issued a notice to me, my lord, as to why my license the registration shall not be cancelled. Is at my lord, page 73. Under section 55 of the, my lord, Metro Vehicle Law. Though, my lord, the cause that has been, my lord, appearing, my lord, it does not, my lord, come within the ambit of section, my lord, 55 for its cancellation. But against this, I have, my lord, submitted my reply at page
Let us see the impute order 2612. Page 78.
Page 78. Okay. Well, here, my lord, my reply as well as the MVI report, those were not at all considered. Only on the basis of an, my lord, information collected from the, my lord, my lord, police station of Digboi, my lord. They said, my lord, they suspended my, my lord.
The suspension for, which was for initially for 3 months,
Yes.
has been extended till disposal of WBC 6839.
Maybe, my lord, may be extended, my lord.
Yes.
Yes, may be extended. So otherwise it will come to an end on 25th March 2023. My lord, my whole contention is that, my lord, this order had been passed without looking into my reply as well as the MVI report.
Now this order otherwise it spent its force on 25th.
Lordship, my lord.
Then what is there to decide?
And thereafter, my lord, they will again extend, my lord, because.
Which
that-
may be,
Which
whether
may be,
they
my
do or not, we do not know.
Lordship, so
What are you contemplating, madam?
Lordship, since this WPC is still pending before this honorable court, and this honorable court has already imposed restriction of the use of that vehicle, my lord. I think.
Why
we
don't we concentrate on 6839 and dispose that?
Yes, my
matter?
lord. That's why I have prayed before this honorable court.
6839.
There is totally different, my lord.
That
No,
was,
see, this order is conditional on a writ petition which is pending consideration from this court. We take this, both these petitions together next Tuesday.
My lord, consider one aspect of the matter,
Now, why do you have an objection to that? In having that writ petition
on Tuesday,
for consideration Tuesday?
for consideration.
Both. See, this is depending on,
My lord, that cannot be, my lord, the other day also this issue was, had come up, my lord, that cannot be, my lord, disposed of because, my lord, the service on the other respondents have not been completed.
we'll see whether the embargo can be extended or not. If we see that the embargo cannot be extended because of some order, this suspension has been done.
No, not that, my lord. The order is pursuant to the, my lord, the direction contained in paragraph 6, that, that you should take action. What action you
And
take?
we have understood, Justice Buzarbora's order, isn't it? Now, if we see that thing has been taken care of, we can clarify that part. See, the whole impugned order of 26/12/2022 is subject to and dependent upon an order passed by this court in a writ petition, which is 6839/2022, which is pending. Let us have the writ petition along with this. If you can clarify that, your matter ends there. It appears that the impugned order dated 26/12/2022, by which the registration of the vehicle in question has been temporarily suspended for 3 months, is dependent on the final verdict in WPC 6839/2022. Full stop. Previous Learned Senior Counsel, however, submits that it is only with regard to certain observation made by this court that has resulted in passing of the impugned order. Full stop. This said aspect can be looked into by having the said writ petition for consideration. Full stop. Para. Register to list this case along with WPC 6839/2022 on Tuesday next. With MD Bora, Learned Senior Counsel Transport Department is present.
I'm deeply obliged, my lord.
But in the meantime, if any order passed, that is subject to the outcome. This
25th, when is the next Tuesday? Next obvious?
I'm deeply obliged, my lord.
You take this back.
My lord.
Lord had already heard this matter on earlier occasions. The two writ petitions, both arising out of the Himolaguri Town Committee, and these standards were floated in December. Now, two main grievances are before your lordship.
Two writ petitions, which one we take first? 8239.
Yes, ma'am. There is one only.
Madam.
There's a vegetable shed, madam.
Hmm?
Construction of vegetable shed.
38329/22. NIT dated? NIT dated?
This is NIT dated.
Who's for the authorities? Madam, you are there for the authorities. Begum? You are for the board. Yes, yes. What is the date of the NIT?
This is 26/8/22. 26th of August, 2020.
We are on the for the vegetable shed here.
My lord. Now, my lord, our main grievance is that they have not completed, submitted the complete bidding documents by way of not signing on each and every page of the bidding document as required by
Who the private
the
respondent?
private respondent.
This is by
Simolguri Town Committee.
Simolguri Municipal Board.
Municipal Board. Simolguri Municipal Board. First grievance is that they have not submitted complete bidding documents.
Who are what?
R7.
Is the selected bidder.
Selected.
Did not submit complete bidding documents.
They have not signed on each and every page as required by the conditions of the tender.
Pages of tender document. Anything else?
Number two, the evaluation committee by the way of their own affidavit, they have changed the rules of the game. When they evaluated the tender documents, they have in the condition for which, because we are all at par, we are all equal tender, we have all qualified equally. Now their Simolguri Town Committee has, municipal board has taken into consideration the fact that they have machineries, which is not in a tender condition. So they have introduced new rules of the game in the evaluation process.
Yes.
These two are main grievances.
That was not a condition, that the bidder with more machinery will be preferred.
No,
That is not a condition.
Not in the NI.
So they have taken into consideration something which is extraneous
Which
to
is
the,
which are outside.
extraneous to the, outside the purview of the contract.
good.
Okay,
Very good.
that is your case.
Fine.
Otherwise, your rates are at par.
At par. It's all right.
Financial rates at par.
Fine.
You have to be technically qualified.
I'm technically qualified. During the bidding process, when the technical bids were opened, it was for everybody, when we all were present, it was already decided verbally that they have not qualified the technical bids, the respondent number 7 in both the cases, because they have not signed on each and every page of the tender document. And number 2, they have not summed up the total.
And the other writ petition, what is your grounds?
This is the same matter. They have not signed, they have not
And
submitted.
regarding the rules of the games,
That is not there. That is
Okay.
not there.
so
But
far as vegetable side is concerned, the additional condition is that
the respondent number 7, the
Seven?
winning bidder has got machinery.
what kind of machinery? Building machinery,
Maybe JCBs and all.
building machinery.
Okay.
That is in connection to vegetable shed only.
Vegetable shed.
Only vegetable shed, not the lake.
Not, no,
Yes, Ms. Begum.
We have filed our affidavit,
Here for R,
4 and 6.
or 4 and 6, yes. Affidavit filed.
Yes, my lord. In which petition 8239.
See, he has made two contention. One is
One.
finding defect with the bid submitted by the respondent number 7.
Yes.
What is the defect? The fact that all the documents have not been submitted, number 1. Number 2, all the pages of the tender document have not been signed.
Yes.
Okay, and so far as the selection is concerned, contention is that though the rates are at par, he has been preferred because he has got additional machineries, which is a condition not contemplated in the contract. So once you take that condition into consideration, you are changing the rules. If that was a consideration, he would have also done something. Yes. Next. How do you respond?
Yes, my lordship, actually, as per evaluation committee's meeting, the tender was in paragraph 4, my affidavit.
Your file affidavit
Yes, my lordship.
by respondent number?
Respondent 4 and 6.
Yes. Page
Page 29, running page.
Bidder submitted their bids including the present petitioner, respondent number 7 and Vidyut because so far the petitioner is concerned of his bid value. Similarly, bid value of respondent number 7 is on both
Paragraph
the
4. Paragraph 4.
Paragraph 4. Both the technical and financial bills are opened on 13/9/2022 and both are found to be technically qualified. Similarly, the financial bids were obtained and all the 3 bids were found to be below 5%. However, the bids of Vidyut because Dotto is concerned, amount is not filled up properly. Therefore, there were overwriting. Total has not been mentioned. Thereafter, a comparative statement was prepared of 3 bidders and there was difference of 1 paisa between the petitioner and respondent number 7. The tender evaluation committee in its meeting held on 3/12/22 has found that Vidyut because daughters quoted above rate and Krishna Bora quoted slightly above 5% and whereas the respondent number 7 exact 5% below. So serial number 3 MS Enterprise was selected for the bid. The said meeting was presided by Srimati Kavita Mes, President, Sabyasachi Kashyap, Sri Rajiv Sonal, Executive Officer, Simolaguri Municipal Board, Robin Bora, Assistant Executive Engineer, PWD, Nazira and Amguri Circle, Sri Shankar Prasad Vishwas, Deputy Director, Town Country Planning, Monisha Nasrin, Treasury Officer. According to the contract was awarded in favor of MS Enterprise.
That is not there.
My lord.
Machinery part is not there.
No, I'm sorry, my lord, it's the other way around. The border hull is machinery part. Vegetable shed, I was below, I had quoted 1 rupee less. I had quoted 649. 1 paisa, I'm sorry, 1 paisa less. And that is why I was not considered. In the vegetable shed. And in Bonohal Lake, the additional condition imposed by the evaluation committee is that they have got machinery.
Now, what is the explanation? Your bid is less by 1 paisa.
1 paisa. There's no reflection of their past work done or why are they more technically superior? Why it has been there's no logic or any explanation given in both the evaluation committee.
How have we accepted R7?
Accepted already tender committee's meeting was held where they are on their finding, they accepted the respondent number 7.
Why him, not Mr. Sharma?
Mr. Sharma is slightly above 5%. Slightly above where the respondent number 7 exact 5% below. Finding is there.
He'll do the work at 1 rupee more. 1 rupee more.
1 rupee more.
1 paisa.
1 paisa more.
1 paisa more.
You're also a dangerous bidder. Go to the extent of 1 paisa. Can you produce 1 paisa today? Huh? You do one thing, ask for 1 paisa from him. If you can produce, give it to him. Yes, any criteria you have followed for preferring Mr. Datta than Mr. Sharma?
This information is not with me, my lord. You better tell my senior, my lord. It better tell my senior, my lord.
The senior, Mr. Katok will be here. Should have been here, we are having this for 5 minutes.
Engage another court, I informed him.
I'm not saying. Mr. Doctor, what do you say?
Lord, this case I can say only one thing. Lordship will find, in this case, 50% of the work has been completed. The next one, 100% is over. Now, under given that situation, my Lord, I have placed before Lordship
Shed 50% completed,
50% completed as his
Lake-
instruction,
lake 100%.
and the next one is 100%. So, my Lord, if your Lordships go by the Ramanna's decision, my Lord, a situation which arise, will be given rise to the iniquitous situation so far beneficiary is concerned. So, my Lord, whether your Lordship will like to disturb the situation at this stage. Because now if your Lordship in 50% work, now these 50% is given to
No,
my learned friend's
otherwise
client.
also we are not finding this to be extremely arbitrary or something.
That's the reason, my Lord.
decision is very thin. There's no change. I don't find any difference in the bids.
My Lord, no
They could have gone
difference.
for draw of lots.
Therefore, my Lord, even now, if your Lordship is
And so far as the other bid is concerned, at par, so monohol is
at par,
concerned,
at par,
and here 1 paisa less.
1 paisa less. So therefore, my Lord, it is not that arbitrariness is there so as to make an interference. And
Yes, anything. We'll close this. Then.
Lord,
May not be a fit case.
my lord, what I dispute is that only 20% of the work is done in the vegetable.
in that case, my Lord, I will have to give an affidavit because the instruction is not.
Monohol is complete.
One is also not complete. You're still asking, as far as I'm informed by my chucking counsel, that they have asked for some extension that's this or that has not yet been completed. But my lord, introducing something which is not in a NIT is per se ab initio, my lord.
No, you're correct. But this may not be a very extraneous factor. Having machineries to do the work.
My lord, but that should happen in a tender document.
And you're at par. When you are at par, something to do, yes, he has got machinery.
But
and until that decision is vitiated by Melafedi,
well, that is my lord. But
this is something, a factor taken in respect of the, contemplate the work in question.
my lord, under what, by virtue of what information they have come to the conclusion that the respondent number 7 owns machinery, not in the tender bidding document. They have not signed the tender documents. They have not.
A factor which is wholly irrelevant. They are not going by his looks. So he may be handsome, but they are not going by his looks.
Because my lord, what has happened here? Because one bidder has been he has been disqualified only because he has overwritten in the tender document. And my case is that you have not written anything in the tender document. So both are at par, my lord.
No, they have not. It's not. You have not signed.
I have not signed.
Okay, well, how do you have anyone dealt with that?
My lord.
There is no signature.
My
and few tender papers were missing. These are the first, I think.
No signatures and no cumulative price, my lord. That was they're incorporated.
Do you have the records, madam?
My lord may also kindly peruse the record and.
Well, signature is there.
Don't put your signature now.
No, these are all photo mail signing there. I have seen. My decision may be partial.
File covers are there. It was directed to be produced.
Okay.
Hello, let Mr. Patoki. Aji Gurga.
We are closing this. R Sharma, and senior counsel for the petitioner. I'll hear it. All of Magut separate orders. 8239. Also heard MS Begum, Learned Counsel appearing for the Imolu Guri Municipal Board. The respond numbers 5 and 6. 4 and 6. Who's 5? Hmm? 5-0. What about the, okay. You're hiding. Not a matter to hide. Also heard through DK Sharma, the respondent. R. Sharma, assisted by P. Fukan. Also heard through DK Sharma, learned additional senior advocate, representing the respondent numbers 1, 2, and 3. MS Begum for respondent numbers 4 and 6. Your name? P. Islam for the respondent number 5. And 3 S. Dr. Senior Counsel, assisted by S. Musari for the respondent number 7. Full stop. Considering the subject matter and also the fact, and as agreed to by the parties, the writ petition is taken up for disposal at the admission stage. Full stop, para. And NIT dated 26/8/2022 has been floated or was floated by the Himoluguri Municipal Board in the district of Divasagar for construction of, amongst others, a vegetable shed number 01 at the daily market. Full stop. The said work is under the 15th FC United Fund United Fund for the year 2020-21 at ward number 1, Simolaguri town. Full stop. It is the case of the petitioner that he, being eligible in all respects, had submitted his bid by quoting an amount of rupees 25, 33, 650. Full stop. The bids were opened on 13/9/2022, and as per the petitioner, the bid submitted by him was found to be the lowest, and accordingly, he was declared L1. Full stop. There were 2 other bidders in the fray. Full stop. It is the case of the petitioner that on 3/12/2022, the respondent authorities had, however, granted the work to the respondent number 7. The petitioner, full stop, respondent number 7, followed by a letter of acceptance dated 5/12/2022. It is this action of granting the work to the respondent number 7, which is the subject matter of this writ petition. Full stop, para. Sri Sharma, the learned senior counsel for the petitioner, has submitted that as per information gathered, the bid of the respondent number 7 was not liable for consideration as the same was defective. Full stop. He submits that apart from non-furnishing of certain essential documents, the tender papers, each and every page of the tender document was not signed by the respondent number 7. Full stop. It is the contention of the petitioner that such defects would make the bid of the respondent number 7 invalid, and therefore the interference of this court is sought for. Full stop. Sarah? MS Begum, the learned counsel representing the Himoluguri Municipal Board, however, submits that the contention of the petitioner is incorrect. Full stop. By producing photocopies of the document submitted, comma, he submits that all the bidding documents were submitted by the respondent number 7, and the papers and the pages were also signed. And therefore, the basis of filing of the writ petition is a non-existent one, full stop. The further submits that the work, after the work was allotted, comma, the respondent number 7 had taken over the work and has completed a substantial portion. Full stop. Para. 3. S. Dotto, learned senior counsel, appearing for the respondent number 7, has, while endorsing the submission of made on behalf of the respondent authorities, has reiterated that the tender papers submitted by his client did not suffer from any infirmity or defect. Full stop. He specifically submits that all the bidding documents were furnished and all the pages were duly signed. Full stop. He further, the senior counsel for the respondent number 7 also contends that about 50% of the work has been completed, and at this stage, comma, apart from no case for interference being made out, comma, even in a given case, comma, such interference would only lead to unsettling a settled position, which would be against the interest of public. Para. Sri Sharma, the learned senior counsel for the petitioner, disputes the position by stating that disputes the position regarding the status of the work by stating that only a small portion of the shed has been done, and remaining part is yet to be done. After taking into consideration all the facts and circumstances, comma, this court is of the opinion that since the exercise of jurisdiction under Article 226 is only confined to the decision-making process and not to the decision itself, and not to the soundness of the decision itself, comma, prima facie it appears that the selection of the respondent number 7 has been done in a fair manner by giving opportunity to the other competitors. Full stop. Further, comma, the primary allegation of there being defect in the tender papers of the respondent number 7 being denied by the authorities, comma, at best, comma, the same would amount to a disputed questions of fact, which perhaps a writ court would not enter into adjudication of such disputes. Full stop. This court also finds force in the argument made on behalf of the respondent number 7 that under the present situation where there is no apparent infirmity, comma, interference by this court would also be against the public service, even assuming that even if the court does not accept that 50% of the work has been completed. In view of the above, comma, this court is of the view that the writ petition is that the present is not a fit case for interference, and accordingly the same stands this way. In the next additionally, the learned counsel for the petitioner, senior counsel for the petitioner submits that the respondent authorities have taken extraneous factors into consideration by taking note of the fact that the respondent number 7 is equipped with machineries, which full stop. He submits that no such condition having existed or existed in the tender papers, comma, basing the decision on such factors would amount to changing the rules of the game, which is not permitted under the law. এই contention আমি episode raise করি, episode করি. So far as the contention regarding changing the rules of the games, comma, though this court has noticed that any bidder which machineries may be given preference is not one of the, it was not notified in the contract, comma, the same factor may not be held to be wholly extraneous, more so when the bids, financial bids of the competitive parties are the same. And therefore, in the opinion of this court, basing the decision on the said factor itself will not be a condition, will not be a ground which will vitiate the decision-making process.
Much obliged.
এই দুটো এক্সট্রা হবে, বাকি কিনে একদম তাই দিন। Today we will not be able to complete, but whatever is possible, you do it.
Great, great,
So that at least we can complete it on Tuesday or whatever.
great, great. There are two writ petitions, Your Lord.
Which one we take up?
We'll take up 1061, that's a subsequent writ petition, but it covers essentially the first part also.
Yes.
1061 of 2023.
Mm.
May I just take your lordship to the facts? On 3rd of June 22, an e-tender was issued in regards to 3 rigs for a period of 3 years in Assam and in Arunachal Pradesh. Subsequently, there were few amendments issued in regards to the time and date and all. And subsequently, an amendment was made in which 4th of August 2022 was declared to be the last day for submission of all the tenders. On 1st of August, I amended the MOA, the Memorandum of Association of my company. Now, the peculiarity of this tender is that I was allowed to have a technical collaborator in order to participate and qualify in the technical as well as the financial round of the NIT. So the terms and conditions of this NIT were that if you have a technical partner, which I have, I will qualify to participate in doing the work. I amended my MOA with a consent of these shareholders on 1st of August 2022. The bid closed on 4/8/2022, and I submitted that memorandum of association. Subsequently, queries were raised in which they said that the amendment of the MOA was because you initially did not have what you call the object clause to do the act as capsulated in the NIT. So even if you have amended it on 1st of August, which is only by a shareholder, it requires a registration and a confirmation from the ROC. That was applied subsequently, admittedly subsequently after the tender was closed, and was approved on 18/11/22. Now, your lordships will remember that the process of NIT is still in process. My irregularity, if it was committed on 4th of August, because I did not submit what was required by the Oil India, stands regularized today because that has now been accepted. It has been submitted and accepted. The reason I'm saying accepted is because it has to be given effect to what section says in the Companies Act, because the objection raised is, since you have not had the registration prior to the last date of the submissions, this cannot be accepted that your company was competent to do the work on 4th of August. Admitted, approved by the shareholders. The last part is to be getting into effect under the Companies Act of 2013. Admittedly happened on 18th of November 2022, which was not a criteria in the NIT. The peculiarity is I qualify the NIT in terms of technical and financial ground independently. The technical ground is supported by a technical support, which is an Iranian company which is based in doing this work, not disputed. Neither in the NI and the entire NIT, they say that the MOA that I submitted had to have this requirement. Otherwise, I would have not been able to perform the job. One part of the objection is I could still understand that, yes, I do not have the technical support because I can't do the job. Obviously, I sought to take care of the deficiency by taking an MOU. The MOU was executed with an Iranian company which stood submitted with the tender so that I qualify the NI. This requirement was raised subsequent to the closing of the NIT. And how was it raised? Now that we know after filing the second writ petition, because I was disqualified on the ground of a technical ground, technical commercial ground, saying that your MOA does not have the object clause, and I was rejected. I immediately came to your lordships. Lordships protected me. Subsequently, on the same day, I had informed that we had also taken appraisal of a committee existing with Oil India, which is an independent agency where I can file a representation to see that this is not correct. I filed it. And then subsequently, an order is passed rejecting my representation prior to, in fact, after Oil has rejected my representation subsequently after the passing of the order also. I come and file another writ petition. And your lordships also passes an interim order and protects me to that extent. Now, in this last day, your lordships have requested my learned counsel to produce a document to say, because my objection in the second writ petition is that this decision is completely being influenced by one member of the committee whose company has participated in the bidding process. And I said that this decision is completely biased. In the report, it says that he recused himself. Now, the documents produced, with all due respect, does not give me a date on which this gentleman has recused. Now, the priority of law demands that you should have resigned, because on 4th of August, when they closed the NIT, they knew that I had participated in the NIT. Oil India knew also that I had participated. And the gentleman whose name is mentioned in the NIT as the member for this committee also knew that I had participated. However, from there till 5th of January, where I write a letter invoking this clause, no action was taken. He continues to be a part of the procedure till 5th of January 2023, a letter admitted and filed by me. Interestingly, in December, I write a letter to Oil India. They revert back to me by dismissing my claim. The letter of 1st of January, which I invoke, with due respect, is not replied by the independent agency, is replied by Oil. Therefore, indicating that the fairness cannot be there in deciding a letter like this. Now, my claim always remains is that you cannot disqualify me if I qualify the NIT terms and conditions. I qualify. Financially, there is a requirement that I should have the financial qualifications. I have the financial, because I have no problems in that. The technical support, the deficiencies taken care by an MOU executed by an Iranian company who supports me in that. That is permissible under the NIT. All other documents that has been submitted are all been accepted by the company with no other rejection. Now I will take your lordships to the rejection order passed by the EIM. Why is that important? Page 158. This is the minutes that was happened on 9th of February 2023. May I just read your lordships? Page 158. That's the report. It says note number 1. Sri Sutulu Bihoria recused from the deliberation due to a conflict of interest, as the Honorable IEM is engaged as one of the bidders of the instant tender. Admitted. He recused, not resigned. Before this, lordships, may I just take your lordships to page 147 for a minute. I'm sorry to take you backwards.
One?
147 first. This is a letter written by the petitioner before your lordships to the independent external monitor. Number one is the name of the gentleman, Sutonu Bihoria, IAS. Lordships may see the date on top is 1st of January 2023.
5th of January.
Yes, 5th of January. The order passed by, which is I referred at page 158, is 9/2/2023. That means the letter that I had written was addressed to him, and the gentleman continues to be in that process. And this letter is subsequently been responded by Oil India at next pages 149. This letter is written to the IEM. I expected them to reply to me and say that, no, you rejected for whatever reasons. At page 149, this letter is reverted back by Oil India, which is at page 149. On 19th of January 2023. And the reference, subject and reference is your letter dated on 149, your lordships, annexure N. This is a letter written by Oil India to me. 149. It says reference, your letter dated 5/1/2023. This has been addressed, which I showed at 147 to the IEM. They reject my representation sent to IEM, which has been marked with the same gentleman who says he has recused himself. We do not know on what date he has recused himself. So the entire issue and regret that I have, the fact that this entire process seems to be vitiated by biasness is only because of this, that there cannot be a fair trial. Even if I assume that this gentleman has recused on a particular day, his name still continued. There should have been some kind of a corrigendum informing me. They say subsequently that he's also been replaced. We do not know how, when. No intimations have been sent to us. Now I take back lordships again to the IEM report at 158.
But your representation dated 5/1/2023 at
Yes.
147. You
Yes.
have also marked a copy to the oil.
Yes, absolutely. But the letter is in regards to invoking of an IEM.
No, by this response at 149, oil has only informed you regarding the recusal by that member,
Mr. Bihoria.
Sutanu.
Bihoria. No, your lordship, that is at I'm referring to page 147.
Understood.
Yes, your lordships.
147 is your letter, isn't it?
Yes. No, 147 is my letter.
Yes.
Invoking the IEM.
Writing to the IE.
Yes,
saying
IEM.
that this is the problem.
Yes.
Now, if you see 148.
Yes.
You have marked a letter to the copy of this letter to Oil India.
Yes.
They were aware that you have written such a letter to
Yes.
the IEM. So response comes from not from the IEM but from Oil India.
Oil India.
You're trying to make a case that as if they are hand in gloves, they are a separate agency. A letter making some inquiries with the IEM is responded by Oil India.
Right.
But
They are
Oil-
deciding that.
Oil
They are
India
deciding
was,
that on their behalf.
Oil India was in the know of the letter because they were marked copy.
Not the 147, your lordships,
Yes,
is
one-
it has to be marked to Oil India
Yes.
because that's an agency which is a part of Oil India.
Oil India has, but this by itself, I don't think would be a reason enough.
No, but the fact that he still continues there till 5th of January 2023. The order is of 9/2/2023, rejecting my representation of IEM. That is the decision. 9/2 is only the decision, your lordship, that I'm referring to. 158. That's the decision of IEM, not the.
He recused on 5/1.
No. 5/1 is the letter that I have written invoking the IEM, saying that I want a decision based on this. That
When did he recuse?
Yes, no, we do not know that, your lordships, because this order of 9/2 is an order by the same monitoring agency. 9/2, that date is at 158 on the top. Page 158 on the top. So what I'm trying to link is on 1st of January 23, when I wrote the letter to the gentleman, he still continues to be there in January. 9/2, the order is passed by the agency where they say that this gentleman has recused himself from the deliberation. Now, we do not know when. He was always involved from the time I participated in the NIT. So the external monitoring agency, which is supposed to be an independent agency, could not have decided that. If there could have been one document to show that, yes, I have not been a part of the decision-making process, I could have still been understood. There is nothing to show that he's not been a part of the decision-making process. By recusing himself, he does not, there's still a fair chance that he can influence the entire agency, knowing well that his company has participated in the NIT. And then further, your lordships, at page 149, am I clear on this, your lordships? The agency is an independent, so my letter has to be marked to Oil India.
In the minutes of meeting of 9/2/2023, though it is not clear
Right.
as to when Santanu Buhuria had recused, but the discussions which the IEM had held
Yes.
is after the recusal of Buhuria, because it is in a narration.
It's in the narration, but we do not know when. I'm talking about the
So
initial
even if
exception.
even if you're recused at that moment, then also the deliberations is not in his presence.
He's been a part of it from 4th of August.
That's a different line of argument.
The entire
No,
issue.
that's a different line of argument, whether how, if could have still made some influence on the decision-making process.
Because they themselves said that his company has participated in the NIT. They are one of the tenderers. They are my competitors tomorrow. It is because of them that I am here.
Is that company a party in these proceedings?
Yes.
Have they appeared? What is the name of the company?
Quipo,
That's one number 11.
11.
Oh, Quipo. Quipo has appeared.
Quipo. I don't.
19. This is.
We've already taken the step. Notice has been issued on the last date, your lordship, but nobody appears till date. They are respondent number 11 here in this writ petition also. At page 10.
With regard to the recusal part,
Well, just a minute.
I'll satisfy. They're on it.
Quipo is number?
Number 11, page 10.
There is no endorsement. Let's see the other case. Other case also perhaps there are parties, isn't it?
No, other case because this was prior.
526?
No, because this happened after filing of that writ petition. This order was passed only on 9/2. This writ petition challenges that order of the IEM.
Quipo, what is the address?
Salt Lake, Kolkata.
Is Salt Lake, page 10, plot number something.
11, yes.
Salt Lake City, Kolkata.
Notices were issued only on 3/3. Not even a month has passed. Not be fair on our part. Apart from the fact that we may still allow you to go ahead with dusty service if you are willing to, but
do it.
since it was done on 3/3, at least,
We will do it. There's no problem. The
can you
lordship
serve dusty? Let us take a chance. Let us have this on a date
My
after
learned senior
3/3.
counsel has an urgency in this matter. That's why the matter has been coming up on a regular basis. I don't know, because this will take some time for me also.
If I can,
Do a
I can
service.
satisfy you, my lord. My lord may hear that matter. I'm not, there is a biasness allegation, my lord may hear it. I'll just, my lord, within 5 minutes, I'll show my lord what it is.
Today it will not be.
No, my lord, only thing, my lord, that whether the matter needs to be adjourned for a longer period of time.
No, we can have this thing on Tuesday also.
Tuesday. Okay, my lord.
Tomorrow it might not be possible. Tomorrow and Monday.
No, tomorrow, my lord, it's
Tuesday,
Tuesday, my lord.
have this on Tuesday.
My lord, the problem that
Yeah,
we have.
you may be correct. If we are inclined to pass any orders in his favor, which will be a prejudice to Quipo, then presence would be
My lord, it won't
mandatory.
prejudice Quipco,
If
it will
if
prejudice.
we are not,
Sangam
if we
Vihar.
are not siding
I'll suggest,
with Mr. Bhukan, then Quipo's presence may not be
my
required.
lord, if I may just highlight one factor. One document they have not brought before the lordship.
Tuesday.
Tuesday.
Paucity of time did not allow the matter to be taken up. This court has also noticed that this court has also noted that the notices upon the respond numbers 7, 8, 9, 10, and 11 has been issued by registered post PDD only on 3/3/2023. Be that as it may, since urgency has been expressed. Has been expressed on behalf of the Sri Nair, the senior counsel for the oil, as the matter has been held up, let the matter be listed again for consideration on Tuesday.
And my lord, in the meantime, if they can, if they want, they can take dusty service on board because it's in their interest also.
Even if I take a distiller service, my client is in Noida. So for me, I won't be able to complete the entire process.
No,
within 3
Tuesday, if you are Tuesday, give instruction by you may also be required to serve dusty. Tuesday, we may pass on.
Great.
What is this, Mr. Khan?
This is the
Oh,
documents
that,
that
my
I
lord,
also
I had produced, my lord.
To produce on Tuesday.
Doctor. No, no, Tuesday, can it be at 2 PM, my lord? If not,
We'll try.
2 PM.
Yes.
2 PM.
Yes, sir, anything you have from Shillong?
Grateful.
Will not be able to give you much time, but still, then what is the matter?
Only one thing, my lord, I have received a communication
Yes.
the day before yesterday through RTI regarding the DIPP inspection report dated 18/11/2020
Inspection regarding what?
regarding budgetary support, budgetary final inspection,
For the other side,
eligibility.
Mr. Kyle, is he there? Kyle?
So I'm just placing a record and I'll give a copy to them.
The other side is not here.
I'll
Madam, you have Mr. Kyle's number?
Yes, I know, chamber, I know. I'll give.
You just give him a call. We are here till
Okay.
4 minutes.
Yes.
If he's around, ask him to come.
So my argument is very limited to direct respond number 4 to implement the report. Within a period of 30 days as per board circular. I have already annexed in the petition, lecture 13. And it was also my prayer in the IA application. This is also my prayer.
You have filed an IA.
Yes, IA have been filed. That should be disposed of. There, this prayer was there. I have given a flag mark. Can you see, my lord? We have. It is at serial number 5, House Industries, Guwahati. Inspection was carried out 18/11/20 and recommended for extension up to 23/2027. That is the final inspection report by the DIPP regarding eligibility of budgetary support benefit. I have fulfilled all the conditions. And annexure 13, my lord, of the read petition 95, page 95 to 90.
10 January. 10 January.
10 January 2019, page 97, para 7. Okay, I will give one copy to his chamber. I will take the receipt.
No, you have to pass some effective orders. We need his presence.
Okay.
Can you wait till tomorrow?
Yes. I will wait.
Only list to vote lumber. Come on. 64 items tomorrow also.
Tomorrow,
I'll talk about that. Tomorrow we will call this matter at 2 o'clock.
okay, okay.
Since you're an obstetrician council.
There are 7, my lord.
So tomorrow we'll have it.
Okay.
Come, and inform Mr. Kyle to be at 2 o'clock. Okay?
Gotcha.
If it doesn't require much time, Madam is here, Madam Das. We'll have this matter.
She has come, my lord.
We'll have this matter tomorrow at 2 o'clock. Okay?
Yes, I'm giving a copy to her. This communication, which I have received through RTI.
You take your instructions if it's possible to
Yes.
pass on your orders tomorrow, okay?
This can be taken on record by
Yes, today we have to raise some reference.
post.
Similar order, your lordship, already has been passed in
Yes,
Sai
that we
Enterprise.
know.
Tomorrow at 2
That
o'clock.
also you can give. At 3 PM, right?
Acha.
Tomorrow at
The 24th.
No, 23. Tomorrow 24.